ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆವಾಜ್ ಸೌಂಡ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ,
ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಕೇಳಿಸ್ತಾ ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ನಾನು ಸೆಲ್ ನಂಬರ್ 1 ಸೆಕೆಂಡ್ ಲಿಸ್ಟು ಜಗದೀಶ್ ಶಾಸ್ತ್ರಿ.
ಹಾ
ಪ್ಲೀಸ್ ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಮಾತಾಡಿ, ಕೇಳಿಸಲ್ಲ. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಕೇಳಿಸುತ್ತೆ ಸರ್.
ನನ್ಗೆ ನೀವು ಅಲ್ಲಿ ಮಾತಾಡೋ ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಮಾತಾಡಿ ಸರ್. ಇದರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಕೂಗುವಾಗ ಸ್ವಲ್ಪ. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಎಸ್ ಸರ್, ಎಸ್ ಸರ್.
Fresh matter for preliminary.
My lord, on the B group, my lord, this is a recruitment regarding change of rules, your lordship.
Lordship,
Your lord, file application for early hearing. Yes.
ಅಲ್ಲ B group ನ ಸಮಯ.
B group ಆದ್ರೂ ಅಷ್ಟೇ.
Lordship,
Yes.
divorce matter is there and already notice served to the respondent. So matter is urgent.
Matters ಆದ್ರೆ ಕೊಡಿ. Please
Yes.
give.
2023 matter, your lordship. 2020.
One
Please,
submission.
your lordship.
No.
Since from 1 year it is a pending and already notice is served.
There are older matters, isn't it? Yes.
What-
One
They want to settle the matters. Please,
One MF,
ಏನಾದ್ರು ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ early hearing ಹಾಕಿ.
please.
Not possible otherwise.
Please.
Yes.
one MFA lordship, the appellant Union of India, the railway department.
ಏನ್
file-
ಬೇಕು? Fresh
the-
matter ಏನ್ರಿ?
Fresh ಇಲ್ಲ ಸ್ವಾಮಿ,
ಹಾ.
disposal ಆಗಿದೆ, amount is deposited in the
ಹಾ.
court, that is not transferred.
ಹಾ.
I have my
ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದೀರಾ?
ಹಾಕೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಆಯ್ತು.
Day after
Yeah.
tomorrow lordship.
Yes. Please follow.
Serial
serial number 1, Jagdish Shastri.
serial number
Sir.
27.
Lordship. I am for the,
I have informed the other side. I'm the respondent.
Serial number 27.
27.
Ah.
I'm for the respondent, my lord. Education matter.
Ah.
My lord, it may be taken week after next, my lord.
Who is asking for adjournment?
My lord, I am for the respondent, I asked.
You are asking for
Yes,
adjournment.
yes.
You are appearing for the
Petition.
appellant.
Appellant.
Huh?
Yes.
Serial number 27 at the request of learned counsel for the respondents. Release this matter
On 19th, my lord.
on 19th of November.
My lordship, serial number 33. 3 days time may be granted. My lord. I see couple of, within 3 days we comply the office objection and this matter may be taken Friday, my lordship. Finally. In connected matter, my lord. Connected writ appeal is filed by the JASCOM and contempt is filed by the petitioners, my lord.
Mantesh Patil.
Please,
I'm very
Serial number 33 at the request of learned counsel Shri Sudarshan M.
Please.
Release this matter.
Friday, my lord.
Huh?
This Friday, my lord. I will comply then. All the office objection.
Compliance
Complaint ಸಿಗಿದೆ Friday ತನಕ comply ಮಾಡಿ.
for office objections.
Please.
ಆಯ್ತು on 8th of November.
Much obliged.
My lord, serial number 45, I bring for respondent, my lord.
Hmm.
My lord, kindly refer to Lok Adalat, my lord. Today, Cholamandala of reconciliation is there, my lord. Already I have informed, my lord, Santosh Beradar.
You are for the insurance company.
Please,
Serial number 45. This matter stands referred to the Lok Adalat.
please.
Yes.
Matter for preliminary hearing, my lord.
Today. Yes.
Non-compliance of office objection for first
Lordship,
time.
serial number first, I am Jagdish Shastri, advocate, Lordship, on behalf of complainant, Lordship. My lord, office objection regarding the non-compliance, my lord, this is not necessary office objection. Kindly see the objection, my lord. All our parties are same, my lord. Only kindly see the accused number 2, Lordship. The designation only, my lord, the prayer also, prayer and office objection, my lord, the annexures, the WP writ petition as we mentioned, given, my lord. That is not necessary, Lordship. All are kindly be overruled, Lordship. Local advocate address has to be mentioned, then my lord, also the prayer is the specific, my lord. All prayer is specific, sir.
Huh?
Prayer is
These office objections are required to be complied. You please comply.
my lord, kindly see, my lord, prayer, kindly see, fourth prayer, my lord, prayer, fourth objection, my lord. My
Or
lord,
you submit your response in writing to all the objections.
my lord, I am submit.
A
I will
week's
submit,
time
my lord.
granted.
I will submit, my lord, but kindly be issue the notice also. Actually, I am disturbed from working also.
A week's time is granted to the
Well-
complainant to comply with the office objections.
My lord, my lord, the office objection regarding, my lord, kindly see. Similar writ petition file, my lord, in writ.
Serial number 2,
Whatever you have to say, you put it in writing. We'll see.
Nagaraj
Yes.
Patil.
My lord, kindly take it tomorrow, Lordship. Kindly take it tomorrow, Lordship. I will
No.
put up.
No. Yes.
Lord,
My
week's
lord.
time, week's time infectious ಆಗಿದೆ mostly.
My lord.
At the request of learned counsel for the petitioner, release this matter on 11th of November. Yes.
Serial number 3, government advocate.
2 weeks time may be granted.
Huh?
2 weeks Lord, for compliance of the office objection,
Request of the learned government advocate. 2 weeks are granted for complaints of office objections.
CL number 4, Vasanta Kumari P.
Lord, 1 week of time may be given.
Same order. 1 week at the request of learned counsel for the complaint.
Non-compliance of office objection for 5th time, CL number 5, Vivekananda Patil.
2 days may kindly be granted. I will comply. Earlier, office objection is complied and deposited also cost. Subsequent office objection is raised, my lord. 2 days.
Cost salary pay ಮಾಡಿದಿರಾ?
Pay ಮಾಡಿದೆ, my lord.
ಯಾವಾಗ? Why have you not given the acknowledgement?
Yeah, thanks. Yeah, cost payment.
As paid.
20.
Acknowledgement, my lords.
As paid, yes. Office objection.
These are the further office objections which are raised.
Huh?
These were the further office objections, my lords. Earlier objections were complied, thereafter few more objections. are
No,
raised.
it says advocate for petitioner has partly complied the office objections and yet to comply the following office objections.
For the first time when the office objections were raised, those were complied, and further, after further verification, my lords, few other office objections are raised. On the earlier date, my lords, the freshly, my lords, raised office objections were partly complied. So for that reason, my lords, which is reflected in the order sheet. 2 days, my lords, will comply the rest other office objections.
Finally, a week's time is granted at the request of learned counsel for the petitioner for compliance of the additional office objections.
Yes.
Yes, ma'am.
CL number 6, Virangoda Mali Patil.
A week's time, my lord. Serial number 6 and 7.
Finally, a week's time is granted at the request of learned counsel for the appellant for compliance of office objections.
CL number 7, Virangoda Mali Patil.
Week's time. Serial number 7, same.
CL number 8, Ganesh Subhachandra Kalaburagi.
A week's time, your lords, finally we will comply, your lord. Great.
Order CL number 9, Shukumar R. Tengli.
ಅಲ್ಲ ರೀ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲಿ ಇನ್ ಯುವರ್ ಮ್ಯಾಟರ್ ಅಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 9
ಮನ್ವೇಂದ್ರ
ಶಿವಕುಮಾರ್
ರೆಡ್ಡಿ.
ತೆಂಗ್ಲಿ ಅಲ್ಲೂ ತಂದಿಲ್ಲ ಅಪೇಟ್ ಆಗೋಗಿದೆ ಬೈ ಫ್ಲೆಕ್ಸ್ ಆಗೋಗಿದೆ Despite this court noticing ಏನಾಯ್ತು ಯಾಕೆ ಇದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ
ಇಲ್ಲ
ನೀವೇ ಮೆನ್ಷನ್ ಮಾಡೋದು ಲಾಸ್ಟ್ ಟೈಮ್
ಹೌದಾ ಸರ್ ಇಟ್ ಈಸ್ ಕಲೆಕ್ಟ್ ಮಾಡಿ ಬರ್ತಾ ಇದೆ ಸರ್ ಶಾರ್ಟ್ ಟೈಮ್
ಹಾ?
ಶಾರ್ಟ್ ಪೀರಿಯಡ್ 1 week's time.
Finally, a week's time is granted at the request of learned counsel for the appellant cross-objector to file necessary application to bring the legal representatives of the sole appellant on record, deceased sole appellant on record.
CL number 10, Shivanand Patil.
ಸಾಗರ್ ಪಾಟೀಲ್ ಅವ್ರು ಇಲ್ಲಂತೆ ಗ್ರ್ಯಾಂಡ್ ಮದರ್ ತೀರ್ಕೊಂಡಿದಾರಂತೆ. ಮಿಸ್ಟರ್ ಸಾಗರ್ ಪಾಟೀಲ್ ಫಾರ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಕೃಪಾ ಸಾಗರ್ ಪಾಟೀಲ್.
ಅವ್ರ ಗ್ರ್ಯಾಂಡ್ ಮದರ್ ತೀರ್ಕೊಂಡಿದಾರಂತೆ, ಅವ್ರು ಹೋಗಿದ್ದಾರೆ. ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ನನಗೆ ಒಂದು ಟೈಮ್ ತಗೊಳ್ಳಿ ಅಂತ.
The request of learned counsel for response number 1 and 2. Relist this matter.
And 2 weeks time because I have returned to the company to compromise for 20 lakhs something.
On 21st of November.
Much first. On that day I'll get it. Do letter.
CL number 11, Sandeep Vijay Kumar.
Appearing for the respondent husband lordship.
Yaru?
Sir lordship.
A joint memo has been filed.
Please lordship. There is. Party is present. So file compromise petition, my lord.
Matrimonial case.
Matrimonial.
The parties have filed a joint memo. Have filed a memorandum of settlement under section 89 of the Code of Civil Procedure. Read with rules 24 and 25 of the Karnataka Civil Procedure, bracketly mediation, close rules, 2005. The parties have agreed that this court may proceed to dissolve the marriage held between the parties on 29/12/2017, in terms of the memorandum of settlement. Stop. The appellant wife has voluntarily given up her right of maintenance against the respondent. Full stop. the appellant has also given up all claims in respect of movable and immovable property belonging to the respondent. Full stop. Both parties have agreed that they have no monetary claims whatsoever against each other. Full stop. However, in respect of the right of the minor daughter, it has been agreed that all such rights regarding maintenance, school expenses, and marriage expenses are kept open. Full stop. Next para. ಇದರ ಪಾರ್ಟೀಸ್ ಇದಾರ?
ಇದಾರೆ ವೈಫ್ ಇದ್ದಾರೆ.
ಅರ್ಥ ಆಯ್ತಾ ಏನ್ ಹೇಳಿದೀರ ಅಂತ?
ಸರ್, ಅವ್ರು ಮುಂದೆ
ಹಾ?
ಇಲ್ಲ, ಅವರು
Next para. The contents of the memorandum of settlement are read over and explained to both the parties in Kannada language. And both the parties who are present before the court admit that they have understood the contents of the terms of the settlement. Full stop. Next para. Accordingly, MC number 24 of 2021 on the file of the Principal Family Court at Bidar. Is allowed and disposed of in terms of the memorandum of settlement. Full stop. Ordered accordingly, please.
ಸೈನ್
Huh?
ಸೈನ್
Are
ಸೈನ್ ಮಾಡಿಸ್ತೀನಿ.
yes.
ಸರ್ ಪಾರ್ಟಿ ಸೈನ್ ಮಾಡಿ ಸರ್, ನೀವು ಐಡೆಂಟಿಫೈ ಮಾಡಿ. ಸೀಲ್ ನಂಬರ್ 12 ಸಂಗಮ್ ಬಸವ ಬಿ ಪಾಟೀಲ್.
Require a week's time, my lord, because party is not well. You need to file an affidavit in the first matter. Last date of hearing, I made a submission that, my lord, since daughter has already joined mother, my lord, though, my lord, under GWC, my lord, there is an order for, my lord, the custody with the father. Since my lord, daughter has, my lord, chosen to move with, my lord, the mother. So I do not want to make, my lord, any claim with regard to, my lord, custody.
Release this matter.
He's not well, is the reason.
When
He's
you-
not well. 1 week time, Mary.
Well,
Please.
on 12th of November, to enable the respondent to file necessary affidavit as noticed in the previous order dated 29/10/2024.
Please.
Seal number 13 to Satyanarayana.
Here for the respondent.
Filed a compliance report with liberty to challenge.
Yes, ma'am. We issued the endorsement. Ma'am.
The respondent, Chief Engineer, Water Water Resources Department, has filed a compliance affidavit on 15/10/2024. Stop. Yeah, Annex R6.
Six.
But R5,
R6. R6.
R5 is the first one, the second one is the
R5 is the opinion.
Or page number 15 is the endorsement.
Along with the complaints affidavit, an endorsement dated 21/9/2024.
9/6/23.
Huh?
Next year, R5 is 9/6/23.
R5 or R6?
R6. 21/9.
Endorsement, isn't it?
21/9/20. Yes.
Has been annexed as annexure R6. Full stop. Learned government advocate submits that the directions issued by the learned single judge
Please.
in WP number 204285 of 2018, dated 26/6/2022, has been complied. Stop. Next para. Learned counsel for the complainant, however, submits that liberty may be reserved to the complainant to raise a challenge to the endorsement dated 21/9/2024 at annexure R6.
Yes.
Full stop. Next para. Accordingly, the contempt petition is dropped while reserving liberty to the complainant to raise a challenge to the endorsement dated so and so issued by the respondent.
Yes, please.
I'm applying for respond number 3 KBJ.
Huh?
Respond number 3.
Sorry. Is there?
Huh? R4.
R3 ಇದೆ ಸ್ವಾಮಿ ಅವ್ರ ಹೆಸರು ಇದೆ.
Sir, name is.
That's okay. The petition itself is dropped.
Seal number 14, Gururaj V. Asilkar.
Madam, in this case, now responded in custody, madam, due to non-depositing of arrears in trial court, madam. Hence, last 2 times they have not available respondent. Kindly permit to serve the copy to MS notice to who is appear counsel for that trial court. Madam. Trial court counsel.
Hangagalla.
Please.
Please see the provision in CPC.
Yes.
If a person is in detention,
Yes.
how it has to be served? Serving a copy on the advocate is not service.
No, today is there is.
See the provision, sir.
Yes.
You have to file necessary application
Yes.
accordingly.
No, today I was releasing because of they are ready to depositing the arrears amount.
Ah.
After release is not available.
Ah.
So several times he was residing it out of state. Today definitely they are depositing the arrears amount. Then after depositing amount, definitely were released and they are residing it out of state. Hence, therefore my humble submission, permission to.
The matter is listed before the trial court today.
Right. Today they are depositing arrears amount.
ಮಾಡ್ತಾರೆ.
ಮಾಡ್ತಾರೆ.
ಆಮೇಲೆ
They have release after release he was went to the out of state.
ಅಲ್ರಿ ಏನು ಆಗೇ ಇಲ್ವಲ್ರಿ ಇನ್ನು ನೀವಾಗ್ಲೇ ಇವರು ಮೇಕಿಂಗ್ ಸಬ್ಮಿಷನ್ಸ್ ಆಸ್ ಇಫ್ ದಿಸ್ ಇಸ್ ಗೋಯಿಂಗ್ ಟು ಹ್ಯಾಪನ್. ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. We will adjourn the matter to next week. You please tell us what has happened today.
Yes.
What happens today, you please report. ಎಲ್ಲಿ ಯಾವ ಕೋರ್ಟ್?
Family court, Gulbarga, Kalaburagi.
Kalaburagi. Then we will permit you to serve hand summons then.
Yes, please.
At the request of the learned counsel for the appellant is permitted to take out hand summons to the respondent and serve the same before the learned
Counsel.
How's it today?
Family court.
Family court at Kalaburagi. Yes.
Seal number 15, Vishankar H. Manu.
Lord, in the last state, you will also pass the interim
ಆರ್ಡರ್ ಕಾಪಿ ಅವ್ರಿಗೆ ಹೇಳ್ರಿ ಇವತ್ತೇ ಅಂತಂದ್ರೆ ಇವಾಗ್ಲೇ ಹೋಗಿ ಅವ್ರು ಫೀಸ್ ಕಟ್ಬಿಟ್ಟು ತಗೊಂಡ್ ಹೋಗ್ಬೇಕು. ಇಲ್ಲಾಂದ್ರೆ ಇಟ್ ಡಸ್ ನಾಟ್ ಸರ್ವ್ ಎನಿ ಪರ್ಪಸ್ ಇಫ್ ದಿ ಮ್ಯಾಟರ್ ಇಸ್ ಲಿಸ್ಟೆಡ್ ಟುಡೇ. ಇವಾಗ್ಲೇ ಹೋಗ್ಬೇಕು ನೀವು.
Please.
Ask them to type this order and give it. Yes. ಅದೊಂದು ಟೈಪ್ ಮಾಡ್ಕೊಡ್ರಿ. Yes.
This matter, my lord, last occasion, your lordship is directed me to get the instruction, my lord, regarding the notification. That, my lord, I have not yet received the same, my lord.
That's why, it's another week time, lots of private and 19th, my lord. 11th, you lots of private, my lord, I'll get it.
Release this matter. At the request of the learned government advocate, release this matter on 12th of November.
Please.
Full stop. The interim directions given on 24/10/2024 shall continue till the next date of hearing.
Please.
No, regarding copy already on the same date I have served and enclosement I have produced my lord before the court. Office did not verify the enclosement.
N copy?
Regarding copy, WP copy, written up in copy and notification copy I have served on the same day, my lord. Along with memo, I have produced the enclosement in the last page. So office did not see regarding the service of.
Copy not.
I have served the copy, my lord.
Next para. Learned counsel for the appellant submits that he has served copy of the appeal memo.
So the
And
appeal memo and notification. Appeal memo and notification dated 20.
Notification dated
9/10/2024, my lord.
on the learned government advocate.
Government advocate as well as respondent number 3 counsel.
And the learned counsel for the other respondent.
Enclosement I have already produced, my lord.
Stop. Learned counsels, learned government advocate and learned counsel for the other respondents do not contest the submission made by the learned counsel for the appellant.
Seal number 16, Nitesh Padiyal.
Appear for the complaint.
Huh?
I appear for the complaint. Appeal is there. Connected. My lord, lordship permission, my lord. For filing the contempt, they have preferred the appeal, my lord. Appeal is also connected.
Yes.
My lord, the prima facie case, my lord, with regard to this, the payment concerned about the labors, my lord, the directions given by the learned single judge is, as of now, it's a subject matter before the appeal, my lord. Appeal is also a subject matter before.
Which is that copy of that.
Yes, it must have been connected, my lord. 2002.
Allah, last time you had made a submission that the coordinate bench of this court has.
Sir, I have filed it. It is there, man.
Yavrali?
Appeal element. 200230. Intra-court appeal is not.
Copy code. This copy code, court officer.
My learned friend got 40 to 50 cases closed only on that count, man. Honorable Supreme Court has confirmed that order, my lord, passed by this honorable by relying on the basis of the order of the Honorable Supreme Court, 40 to 50 cases have been closed. It is within the knowledge of my learned government advocate.
Yes.
My lordship, this copy code. Okay, am I not entitled to know what is it you are submitting? Nothing is in copy code. That's happening. My lord, while passing this order, my lordship's order is a binding on us. Thus, the Dharwad bench, lordship has taken the decision, and we have no options. We have to undergo that the direction. While passing this order, my lordship has to rely on the judgment of this management of Bharat so and so. This copy code, ಇನ್ನೊಂದು copy, ಸಾಹೇಬ್ರಿಗೆ ಇನ್ನೊಂದು ಕೊಟ್ಟಿದ್ದೀನಿ copy ಅದಲ್ಲ. So this pending in the Supreme Court, my lord, we have no, the concerned about this lordship order.
Commissioner of the learned senior counsel.
I agreed, my lord. We have no other.
Based on this order.
Yes.
And the order of the Supreme Court.
Correct.
You yourself have made submissions and got many of the matters
Yes, madam.
disposed of.
So basic is a case, in this case, Bharat case is a main case, my lord. Relying on the Bharat case, Lordship has taken decision. Bharat case is still pending in the Supreme Court. That's what we are. And concerned about the Lordship order, relying on that order by this honorable court is pass an order, it's a binding on us.
Yes.
And we have no other options, my lord, and we leave to the court, my lord, and only with regard to.
But based on this judgment, you said many of the cases, but
Yes,
disposed
yes,
of.
madam.
Do you have a copy of one of the orders?
Manapa.
I have, my lord, several cases.
Bharat case is
If my
pending in
friend
the
is
Supreme
disposed,
Court,
my lord,
my lord,
government
it is
advocate.
pending.
One copy, the same,
That's what
same
it-
orders, we'll ask them to,
I beg your pardon.
we'll pass same.
No,
order.
they did not dispute, my lord, and for that reason, he himself, my friend was there.
My lord, kindly note this, also the Bharat case is pending in the Supreme Court, my lord, in that order.
It is passed over, my lord, I shall file. In single day, 10 to 15 cases have.
I think we can pass this same order. See, idralli, in this matter, we have said, needless to observe that if the decision rendered in the above case is set aside at the hands of the Honorable Supreme Court, and it is held that such an intra-court appeal is maintainable, then liberty is reserved to the appellant herein to revive this case.
That's what my humble prayer last time, my lord, the same thing, my lord.
Same orders.
But in
Darwin
that
order.
case, my lord, subsequent.
Originally,
I-
that case is still pending.
Pending in the
That's why we
Supreme.
have said,
Please,
case alli,
oblige.
the Supreme Court says, no,
Yes, yes.
intra-court is maintainable, then liberty is granted to them. So you pass same orders as in writ appeal number 1000230 of 2023, dated 12th of April 2023. Same orders. Yes.
Let the Supreme Court, the case also mentioned in that, my lord, which is pending for that.
ಮಾಡಿದರೆ ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ
Done,
ಹೇಳಿದೀವಿ.
done. Please,
Otherwise, why, how would they mention?
please.
Please see this, ತೋರಿಸ್ರಿ ಅವ್ರಿಗೆ.
My lord, I, yes, please.
So same orders, writ appeal
ಇದರಲ್ಲಿ ಇದು ಮೆನ್ಷನ್
is disposed of in terms of the same order. ಈ writ appeal.
ಇಲ್ಲಿ
Then what about the contempt petition now?
ಇದರಲ್ಲಿ Supreme Court in mention ಆಗ್ಲಿಲ್ಲ, my lord. ಇದು the division bench of this order court is.
First paragraph.
I agreed, my lord. The number I.
The original case that is still
Yes,
pending.
yes, in the view of the
Supreme Court.
render management so and so, Bangalore, it's
Ah.
reported
ಅದೇ.
pending in the Supreme Court. That is
So
enough.
same orders.
That's what I prayed last time.
Writ appeal is disposed of in terms of this order.
Yes.
Now what about the contempt?
My lord, the consent about this contempt, my lord, week's time may be granted, my lord.
Your lordship,
Suppose if it is
your lordship, since 87, my lord, they have been litigating the matter. They are at the verge of retirement or at the verge of death, my lord. 55 to 60 years of age. They are rustic villagers. And after taking into consideration that they are entitled for
That is on the
reinstatement,
merit of the
by
case,
taking
ma'am.
into consideration their age, the London single judge was pleased to order for compensation in lieu of reinstatement. And my friend, the colleague, the Lord Government Advocate has orally submitted that 2.5 is enough. In fact, the London single judge was wanted to order for compensation of and only after filing the contempt petition,
We
my
are not
lord,
question about the
50,000.
2 lakhs 50,000 is not a big matter, my lord, is concerned of the government. My lordship is aware that the lakhs of peoples are working under the same.
ಅವೆಲ್ಲ ಇಲ್ಲ.
That is a law is
That
going to be, the
Exaggerated
law is
figure,
going
you
to be
please
declared.
take it from me, it's an exaggerated figure, whatever you are saying. You may hardly have about 100 or 200 of
No,
them.
no, my lord, not
No, sir.
only for this department, my lord.
ಅದು ಇಲ್ಲ.
ನಾಲ್ಕು ಇದರಲ್ಲಿ ಇರೋದು,
ಇಲ್ಲ,
ನಾಲ್ಕೇ ಜನ.
ಇದ್ರಲ್ಲಿ ಇಲ್ಲ. We are not about,
ಇಲ್ಲ ಸರ್, ಯಾರು ಉಳಿದಿಲ್ಲ ಸರ್.
my lord, not,
Give you a week's time for compliance. If you want to comply, you comply, otherwise we'll.
After filing
proceed
the
with
contempt, my lord, 1 year time they have taken, and thereafter they file the writ appeal.
The contempt petition ಅಲ್ಲಿ, in view of the disposal of the writ appeal filed at the hands of the respondent state by order of even date and at the request of the learned additional advocate general, release this matter on 12th of November.
No, my lord, instead of 12th, my lord, 19th, the government procedures.
19th of November to enable the respondents to comply with the directions issued by the learned single judge.
Apply.
Yes. Huh? Learned counsel, Sri Nitesh Padiyal takes notice for the respondent and Takale, already Amel dispose.
Apply.
Delay condoned.
CL number seven.
Is this a 453 days?
453.
Allah, delay condoned, brother. Having regard to the nature of the litigation brought before this court and the directions issued by the learned single judge to the appellant herein to pay a sum of rupees 2,50,000 to the respondent. Each as full and final settlement.
Please.
This court is not inclined to condone the delay. Full stop. The writ appeal is dismissed both on the grounds of delay and in view of the orders passed by the Honorable Supreme Court.
Apply. Delay control madidre nothing will harm also.
Hello, sir. Only after filing the contempt, after taking 1 year time, they file the writ appeal.
Learned senior counsel also no objection and said the only discussion.
For disposal.
The delay consent has to be condoned.
Yes.
Please.
CL number 17, Ravi B. Patil.
Malad, in this case, Malad, in this case, Malad, the consent.
Upward.
Yes, Malad. So, Malad, here the who has appeared, I mean, before the learned single judge, the petitioner was saying that this is a deemed conversion after the time lapsation of the 4 months from the date of application. Malad, based on that, the learned single judge passed an order. In this case, Malad, the same day where it has been came and without giving an opportunity filing of the statement of objection, the decision was taken. What was the ground on merit of the case in the writ appeal, Malad? The opportunities we have not been provided by the learned single judge. If the opportunities comes to me, then what was my ground before the learned single judge? My ground, Malad, first of all, the property is not an absolute ownership of the property belongs to the petitioner because it is a subject matter of the works. There was a government notification. Unless the government notification is a set aside, Malad, the petitioner cannot be say that he is absolute owner of the property. So that the opportunity, since it is not done and we are not brought to the notice of the.
You should understand. All this was taken note of and we have passed an order on 29/10. If you have read that order, you should understand that the matter has gone up to the Supreme Court. And the Supreme Court has dismissed your SLPs. Why do you want to make this kind of submission? I can understand if the property you are claiming is a government property. That is not so. You are saying simply contending it's a property belonging to the Waqf board.
Now,
who are you to contend?
Malad, the answer to be your lordship, the humble prayer, Malad, to answer. As a deputy commissioner to pass an order, what is my discretionary powers or as per the law, 95 it's a powers to me. If the petitioner is absolute owner of the property, then it is definitely it is applicable deemed time limitation. Even I pass, not pass, it is a deemed conversion. No doubt that. Malad, the deputy commissioner, the moment once is noticed that the petitioner is not an absolute owner of the property, it's a subject matter of by notification itself. As a notification by itself is a government.
The same matter has gone to the Supreme Court and the SLP has been dismissed. Why are you arguing like this?
That's it.
I have noticed this in the previous order.
Kindly have it by 2:30. 2:30.
What is your preparation then?
My instruction,
specifically written down all this so that you will be able to take a decision.
Malad, here the notification of the in this case, Malad.
prayojana?
I mean, the division bench, I'm saying that, which is covered matter in the Justice Mudgal is passed an order. In that order, the notification concerned, I'm going to say. So kindly have it by 2:30, my lord, submit it.
I pass over.
Correct, that's what I'm saying, notification. Up to 20, my lord.
Huh?
17 to 20,
Ena?
17, 18, 19, 20.
same matter.
17, 18.
19, 20.
ಆಯ್ತು.
Fine, sir.
Number 21, Ravi B. Patil.
Lord, in this matter, my lord, last occasion, my lord, this is regarding additional list, my lord, we have to issue. Lord, another 3-4 candidates are there, my lord. But that is the reason, my lord, matter was placed before the government to take decision for this.
Kindly pass over.
21.
Yes, 21, my lord, this is, we made the submission that, my lord, the matter is pending before the Supreme Court regarding the, my lord, same notification. But others had taken the contention that, my lord, this is not coming under that, my lord, category. Now, my lord, we have to go into issue the additional list. Now, another 3-4 candidates are there, my lord, same candidates. We place the same before the, my lord, government to take decision or make necessary application. That is the reason, my lord, 2 weeks time, maybe, my lord, whether we have to, my lord, issue additional issue or, my lord, that is the.
Huh?
But because, my lord, we have to issue additional list, my lord, to this candidate. Same, my lord, another 3-4 candidates also coming before us also. That's why, my lord, we place the same before the government. Government is requested the, my lord, to make necessary application for issue of the additional list before the apex court.
Why they have to issue, give an application?
But we have to give because we prepared the, my lord, SLP before the Supreme Court, my lord. There, my lord, we have to seek permission to issue additional list. But that is the reason, my lord, 2 weeks time may be granted, my lord. That is the instruction by the government.
Kindly pass over.
First candidate is not joined the service, my lord. She automatically she is eligible.
We have noticed, we have noticed the orders issued by the Honorable Supreme Court, giving you liberty.
Yes, that is the only one. That's why.
Where is the question of again filing an application?
Liberty in the sense.
We have
my lord.
noticed that in the order also.
Yes, but that is we have
Having regard to the said category of posts which are not involved in the litigation pending before the apex court, it was directed that the state is at liberty to fill up the vacant advertised posts by reserving 500 posts.
That's why.
Liberty is already given. Where is the question of you filing another application?
Not another 3-4 candidates are there, my lord. For that is the reason, my lord.
Paradilla.
You will also pay it on 19th, my lord. At least, my lord, we'll get the, my lord, positively. But whatever, my lord, that is the discussion is before the, my lord, department, my lord, for that is the reason.
In the order dated 21/10/2024, this court has elaborately noticed the contentions of the learned additional advocate general and the orders passed by the Honorable Supreme Court. Full stop. Having regard to the liberty reserved by the Honorable Supreme Court, permitting the state to fill up the vacant advertised posts by reserving 500 posts. Full stop. In that view of the matter, we had adjourned the matter at the request of the learned additional advocate general to secure instructions and make submissions regarding the appointment of the petitioner. Full stop. However, today, once again, the learned government advocate submits that necessary application will have to be filed before the Honorable Supreme Court to seek permission to pass an order of appointment in favor of the petitioner. Full stop. Next para. This court is of the prima facie opinion that since liberty has already been reserved by the Honorable Apex Court, question of filing one more application seeking liberty or permission to issue orders of appointment in favor of the petitioner and similarly placed persons, comma, would not arise. Full stop. Next para. However, the matter stands adjourned, comma, once again at the request of the learned government advocate, only for compliance of the orders passed by the learned single judge. Full stop. If orders are not complied, this court will proceed to consider the contempt petition in accordance with law. Full stop. Release this matter on 19th of November.
Please.
CL number 22, Ganesh Nayak.
This matter, my lord, we comply the order of the learned single judge, my lord. We already filed the affidavit on 5/9/2024.
Yes,
Considering the representation, my lord, and to pass the order.
sir.
Please, brother, he is the consider.
Complaints agide.
He is the, he imposed order was the pass against the petitioner.
Annexure R3, my lord.
Which is the order?
Annexure R3, my lord.
Allah.
My lord is the he page number, my lord is the
Annexure
A,
A.
my lord is the
Renuka Yellamma.
Oh, yes,
Devasthana, my lord is the key.
directed to consider the representation submitted by the.
There is the key dispute regarding in the, my lord, the survey number 480, my lord, the 3 acres, 11 guntas. The Renuka Element Devasthana, my lord, is the key established in the back in the 50 to 60 years. There is some difference between the key villagers and, my lord, the petitioners, my lord, the trust. On base, my lord, the suit was the key filed, my lord. The suit is the key pending. In meanwhile, my lord, the respondent at that time, my lord, the conducting the case survey, my lord, is the for the purpose of the land, my lord, is the establish of the temple is under of the government land, my lord. On that base, my lord, there is the where the direction to find the respondent at that time.
That order was passed on 23/7/2024.
Yes, ma'am. 23/7/24, ma'am.
And within 15 days, the report was required to be submitted.
Yes, ma'am.
Andre alla agogide.
We directed
Report
to
is
the.
the not, report is not submitted, my lord. Only the key import order was the key passed, my lord. The representation consider, my lord. Report in.
Objections
Oh.
have been rejected by this order.
Pause.
You were objecting
Pause. Same to be
for the
rejected.
survey.
Pause. Same
Now,
is the.
The deputy commissioner has considered your representation
And the same
and
is.
has held that it's a property belonging to the
Government.
temple trust, and therefore your objections are rejected. If you are aggrieved, you proceed in accordance with law.
Please.
the respondent, Deputy Commissioner, Yadgir, has filed an affidavit, compliance affidavit, on 5/9/2024, enclosing copy of order dated 23/7/2024. Full stop. Learned Government Advocate submits that the directions issued by the learned single judge in WP number 203286 of 2023, dated 11th of December 2023, was to consider the representation dated 21/11/2023 given by the petitioners and to pass suitable orders in accordance with law within a period of 6 weeks from the date of receipt of a certified copy of the order. Full stop. Learned Government Advocate submits that although there was a delay on the part of the Deputy Commissioner in passing the order, nevertheless, the representation given by the petitioners have been considered and rejected. Full stop. The petitioners were opposed to any survey being conducted in survey number 230 of Vankasambra village, Gurmitkal Taluk, measuring 3 acres and 11 guntas. And 43 acres and 1 gunta in survey number 185. Full stop. Next para. We have perused the orders passed by the learned single judge. Stop. It was the contention of the petitioners for complainants that three acres and 11 guntas in survey number 430 of so-and-so village, Taluk, stood in the name of Sri Basalingappa. And later on, it was divided amongst his legal heirs. Full stop. It was contended that the petitioner trust has filed a suit in OS number 116 of 2023 before the civil court at Yadgir. Full stop. Therefore, the petitioners are opposed to any survey being conducted on the said property. Full stop. Nevertheless, the learned single judge directed the Deputy Commissioner to consider the representations given by the petitioner and directed that suitable orders be passed within a period of 6 months. Full stop. It was also made clear that the learned single judge had not expressed any opinion on the merits of the matter. Full stop. Next para. We are satisfied with the action taken by the respondent Deputy Commissioner. Full stop. Although there was a delay in passing the orders, nevertheless, orders have been passed by the Deputy Commissioner on 23/7/2024, which would comply the directions issued by the learned single judge. Full stop. Next para. Accordingly, we proceed to close the contempt petition, while reserving liberty to the petitioner trust to redress their grievance in accordance with law, having regard to the subsequent order passed by the Deputy Commissioner.
Yes, please. Much.
Serial number 23, Ratnayan Shoyogina.
Yes. The officer raised the objection. He produced the typed copy of Annexure B, my lord, Varshik, kindly see Annexure B, it is readable, my lord, ink page 34. Therefore, I made a submission, my lord, to accept the same.
Legible copy of
Annexure B in the writ petition.
C in annexure A to be filed. Adenamadu.
Alla, other, uಳಿದಿದ್ದೆಲ್ಲ comply ಇದೆ, except Annexure B, my lord. My submission in respect of Annexure B. Ink page 38.
38.
Yes, ma'am. Was produced in the writ petition, my lord. When I, yes.
Office objection. At the serial number 3 is overruled.
My lords, in the writ petition, my lord, I challenge Annexure F. Annexure F is a consequent to Annexure E, my lords. And the harassment was brought to the notice of the Deputy Commissioner, produced at Annexure E. The Annexure F was passed. Only deputing the petitioner, where there is no vacant place. Therefore, approach this court, my lord. This honorable court granted an interim order on it was stayed, my lord.
Stay of annexure F.
Yes, my lord. That was petitioner was deputed to the
How the annexure F?
F, my lord, ink page 46, my lord. From Shapur to Kakera, she was deputed. Where there Kakera, there was no place. Since
So the matter is pending
yes, my lord.
before this court.
Yes, my lord. Though they produce the sorry.
Division bench or single?
Single.
Huh?
Single.
Then you go and bring it to the notice.
Allah, consequent, my lord, when they will not take any contempt to initiate any contempt proceedings, my lord.
Learned single judge has also got powers.
Allah, they will send.
No.
Allah, take, they can't take.
We do not know.
They can't initiate any action, my lord. They can't initiate, single judge can't initiate any contempt proceedings, my lord. That's the most, they will refer to the bench. That is therefore, from beginning only, if they are not complied with any interim order, my lord, they will always filing the contempt petitions, my lord. That is
List this matter for admission after 2 weeks.
literally.
Yes.
Allah, they single judge can't
Mentioned before the learned single judgment. Yes.
They can't initiate, my lord. They can't initiate contempt proceedings.
Madam.
They will refer it to the
Learned. Yes, he will. If it is necessary, he will refer. Yes.
Serial number 24, hearing on here, liaquat for
These are all matters pending.
Yes, my lord.
And the learned single judge will know what exactly to be done. Having regard to the orders, if the steps taken,
yes,
whether it was in disobedience of the orders passed or without notice, it was not brought to the notice of the authority. That all the learned single judge will see.
Allah, produce all those letters, my lord. It is brought to the notice of the authorities, my
Next matter.
Hearing on here, serial number 24.
Yes.
At the, your lordships, in this matter, earlier my senior was appearing for the respondents, your lordship, respond number 1 to 7 and respond number 11. And in the year 2020, your lordships, the matter has been dismissed for non-prosecution. Now they have filed application, your lordships. We tried to contact the clients, your lordships, they are not responding.
So notice had to be issued.
Yes, yes.
Huh?
Yes, your lord.
Where is that order of dismissal? Idರಲ್ಲಿ ಇದೆಯಾ? Learned Counsel, Shri Ganesh Subhash Chandra Kalburgi, whose name is reflected in the cause list as against respondents number
1 to 7.
7 and 11 submits that his senior Shri Amit Kumar Deshpande was appearing for the said respondents. Stop. However, the appeal was dismissed. For non-prosecution and for not furnishing the paper books, by order dated 26/2/2020. Full stop. This application in IA number 1 of 2024 has been filed on 2/9/2024. There being a delay of more than 3 years. Stop. In the meanwhile, Shri Amit Kumar Deshpande has been appointed as designated senior counsel. Full stop. Moreover, the learned counsel has tried to contact the parties and they are not available. Full stop. Therefore, learned counsel submits that his name may be removed from the cause list. Full stop. Next paragraph. Office is accordingly directed to remove the name of learned counsel Shri Ganesh Subhash Chandra Kalburgi from the cause list. Full stop. Next paragraph. A week's time is granted to the appellants to take steps for service of notice on IA number 1 of 2024 on the respondents.
Great.
Seal number 25, additional government advocate.
But in this matter, my lord, here first stay is prepared, my lord, that we are going to file within 2 days, my lord. You also have it on the 11th, my lord. We are not, by mistake, my lord, we are not filed the
Learned government advocate released this matter on 11th of November.
Seal number 26, Siddhartha B. Pujari.
Kindly pass over, my lord. Kindly pass over, my lord. Senior held in court or for.
Pass over.
Seal number 28, Ratnayan Shivayogimat.
That's in page 18 is operative portion of the order passed by the learned single judge. Think page 18, my lords, the operative portion of the order passed by the learned single judge, my lord. Third one, the endorsement was possible. Then the applicant of the petitioner along with the representatives to be furnished by the petitioner within a period of 15 days from today shall be considered in accordance with law by deputy commissioner and pass suitable orders within period of 3 months. Accordingly, I have made a request produced at my lord on 17/4/2024. by enclosing the order passed by the Honorable Court. ma'am. Para 10, my lord, there is an observation. At liberty to fresh represent before deputy commissioner to consider their application in accordance with the enclosing the copy of Annexure K. Annexure K was, my lord, it is adjacent land was converted. Therefore, they directed me to produce that Annexure K. ma'am. Accordingly, I have produced the Annexure K and filed the request letter.
Issue notice to respond number 1. Learned government advocate takes notice for respond number 2. Learned counsel for the complainant is directed to serve copies of the contempt petition on the learned government.
Please, 34 is also same, connected, that is a single judgment.
34.
Yes, my lord, both writ petitions, my lord, in the common judgment,
34 same one.
please.
Seal number 29. Bapugoda Siddhappa.
For the appellants, claimant's appeal for seeking enhancement.
Huh?
Claimant's appeal for seeking enhancement, the notice to the respond number 1 may be dispensed. The already the insurance company is satisfied by the satisfied notice. Yes. The second respondent is the branch manager, New India Insurance Company. Notice.
New India Assurance. Huh?
Yes, notice. Sri Shanabasappa Ba.
New Vidira.
Yes.
Sharanabasappa M. Patil.
Yes.
Learned counsel Shri Sharanabasappa M. Patil present in the court takes notice for
Respond number 2, notice.
respond number 2. Stop. Next para. Learned counsel for the appellants has filed a memo dated 5/11/2024 seeking dispensation of notice to respond number 1 on the ground that respond number 1 is the owner of the
Vehicle.
and the liability has been passed on respond number 2 insurance company. Full stop. Next para. At the request, at the risk of the appellant, notice to respond number 1 is dispensed. Learned counsel for the appellant is directed to serve copies of the appeal memo along with annexures on the learned counsel for respond number 2.
There is delays there, delay may be condoned and refer to Lok Adalat. They may be settled in the Lok Adalat.
57 days. 857 days.
I am not claiming any interest on the point of delay. The appellants are not entitled for delay period.
Next para. Order on IA number 1 of 2020. There is a delay of 857 days in filing the appeal. Full stop. However, learned counsel for the appellant submits that the appellant may be denied interest during the said period of delay. Full stop. Next para. Accordingly, IA number 1 of 2024 is allowed while condoning delay of 857 days. Full stop. It is also made clear that the appellant shall not be entitled for payment of interest during the delayed period of 857 days.
Refer to Lok Adalat.
Next para. Matter stands referred to Lok Adalat. Please.
Seal number 30. Maruti S.
Appeal for the lords petitioner, my lords. That's the matter pertaining to promotion, my lords. That's the before the honorable adjournment tribunal, my lords. not appreciating grounds urged by the petitioner, my lords. Kindly see annexure, my lords, A6, page number 78, my lords. That is the impound order issued by the, my lords, respondent, my lords.
Transfer,
Allah, Swami, promotion, Swami.
promotion.
Yes, my lords. And a similar matter, my lords, recent time, my lords, Honorable High Court of Karnataka, my lords, at Bangalore bench, allowed and cost set aside the judgment, my lords. It is the same post, same cadre and same department, my lords. Subject matter also same, my lords. In writ petition number, my lords, 19407/23, my lords.
Learned government advocate takes notice for both the respondents. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned government advocate. Next para, release this matter on 12th of November. Please get copies of that.
Please, my lords,
order.
I will file memo along with memo, my lords.
Serve the same on the learned
Yes,
government.
yes, my lords. Much obliged, my lords.
Seal number 31, Siddharuda B. Pujari.
I am Kevatar, my
My lord, IF for dispensation.
now copy is issued.
Translation copies, IF for dispensation.
Copy ಇವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಲೆ ಕೆವೇಟರ್ಸ್
ಯಾವುದು?
ಕೆವೇಟರ್ ಇದೆ ಇವಾಗ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೇಲೆ
But IF may be, IF for dispensation of production of
Early bidri.
translation copies.
Learned counsel for the respondent caveator submits that a copy of the writ petition has been served on the learned counsel this morning.
ದಿಸ್ ಮಾರ್ನಿಂಗ್
Full stop. Next para. Release this matter on 12th of November.
ಓಕೆ
Seal number 32, Bapugoda Siddhappa.
Here for the appellant, claimant's appeal for seeking enhancement mercy. He noticed to the R1 be dispensed. He was placed ex parte before the tribunal.
Huh?
He was ex parte before the tribunal. Respondent number 1 is owner of the vehicle. And the insurance company has satisfied the award amount. Respondent number 2 is the general manager, Reliance General Insurance Company.
ಯಾರಿದ್ದೀರಾ? ಪ್ರೀತಿ ಪಾಟೀಲ್, ಸುಭಾಷ್ ಮಲ್ಲಾಪುರ್, Rahul Asture.
Rahul Asture is not panel advocate.
Not there. So only two are there.
Two person. Subhash Mallapur and Preeti Patel. Anyone of them?
Learned counsel. The Subhash Mallapur is requested to take notice for respondent number 2. Learned counsel for the appellants is directed to serve copies of the appeal memo on the learned counsel for respondent number 2. Next para. As dispensation, respondent number 1, same order. Yes.
Denying the interest of the 540 days.
Huh?
540 days is there. The appellants are not entitled to deliberate interest. And local.
540 days delay. Huh? Same. Refer to local.
Yes, Mr.
Pending matter, seal number 35, Ulepaya Road.
For the petitioner block.
Yes.
Petitioner has challenged the order of the service tribunal where the application of the respondent number 4 has been allowed and my transfer has been set aside. The Lord will turn to page number 91, annexure E. Annexure E.
The order is at page number 101, is it?
KT order.
Huh?
KT order.
101.
Oh, yes. Before that, my lord.
There is no private party?
Yes, I am appearing for the private. Here, Kevator.
Before the tribunal?
Except ourselves, no other parties. Government else.
Only government was there. Huh?
Yes. I am there, my lord. Because I am the applicant before the tribunal, my lord.
Oh, you are the applicant?
Yes, my lord. My application has been allowed. I suffered the order. He is the respondent. He is the private respondent before the tribunal.
Page number 101 ali.
My lord, your lordship kindly.
My lord, page number 123, my lord.
123 now.
Yes. Two applications were there, my lord. Page number 123. Is the respond number 4, my lord, in application number 20818. And in the subsequent application, my lord, he is not the party, my lord.
I am not made party.
Because in the subsequent application, my lord, I have called in question, my lord, the posting given to the applicant. Lord, application number 20818 of 2024 is the first application, my lord, wherein transfer, premature transfer and without posting is called in question, my lord.
Yes.
During pendency of that application, my lord, the posting is given.
Yes.
Therefore, my lord, the subsequent one more application is filed. Where, my lord, the private respondent is not the party in that application. Both the applications were allowed.
Yes.
My lord will turn to page number 91, annexure E. Here, in this transfer order, this petitioner has been transferred from Lakshmeshwar Taluk of Gadag district. My lord will find on page number 94. My name finds place at page number 20, item number 24. I have been transferred from Lakshmeshwar Taluk of Gadag district to Kalaburagi Urban Development Authority, Kuda, as a secretary. My lord will find at page number 94, item number 24.
ಏನ್ರಿ ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಕ್ರೊನಾಲಜಿಕಲ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಡೇಟ್ಸ್ ಅಂಡ್ ಇವೆಂಟ್ಸ್ ಬರಿಬೇಕು. ಯು ವಾಂಟ್ ಅಸ್ ಟು ಗೋ ಥ್ರೂ ಎವ್ರಿ ಡಾಕ್ಯುಮೆಂಟ್.
ಅವ್ರು ಹಾಕುದು ಅಪ್ಲಿಕೇಶನ್
ಅವ್ರು ಏನಾರು ಹಾಕ್ಲಿ ನಿಮ್ಮ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ನೀವು ಸಿನಾಪ್ಸಿಸ್ ಹಾಕೋದ್ ಬೇಡವಾ? ಸಿನಾಪ್ಸಿಸ್ ಅಂತ ಹಾಕ್ತೀರಾ, ಏನು ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಸಾರಿ,
ಹೇಳಿ ಯಾವಾಗ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿ.
page number, well, I have been transferred on 11th October 2023. 11/10/2023. My lord will find it on page number 93.
Yes, from
Lakshmeshwar Taluka of Gadag district to as a secretary Kalaburagi Urban Development Authority. Here.
Kalaburagi.
Yes. Kuda, Kalaburagi Urban Development Authority, Kalaburagi.
Yes.
Page number 94, my lord will find item number 24. My name finds place.
Yes.
Thereafter, my lord, I have given charge, and while transferring, transfer order says my services are kept at the disposal of the Urban Development Authority.
Yes.
For that, I have to make an application as per page number 98 for permitting me to join to the post of secretary at Kuda, Kalaburagi Urban Development Authority. I made an application on 19/10/23, page number 98. Thereafter, my lord, even district minister also writes to the concerned minister to permit me to join duty. Thereafter, again, district minister writes to the secretary concerned, page number 100.
You are functioning as what at Lakshmeshwar?
My lord.
At Lakshmeshwar, you are functioning as what?
Tahsildar. Grade 2. And here my transfer was secretary. It is equivalent post. Page number, my lord will find 100. Even district minister writes to the secretary concerned to permit me to join duty. Till, my lord, June, they did not allow me to join. From October, I was made to wait for the posting. I was constrained to approach KT Kalaburagi. KT Kalaburagi also given direction to permit me to join. Thereafter, my lord, as per
order,
my lord, an order dated, KT order dated 24th June 2024. 101.
Order the KAT.
Order of the KT, my lord will find page number 101, 101. Operative portion, my lord will find page number 103 to 4, 104. Despite of that, posting was not given to me.
Ah.
Meantime, government has transferred me. Lord will find page number 105, annexure A3. On 31st July 2024, I have been transferred and posted to the post of Tahsildar Kalaburagi. Lord will find at page number 106, my name finds plate at serial number 11. Serial number 11, my name finds place.
Yes.
And Lord, accordingly, I joined duty on 1/8/2024, page number 111. My Lord will find 111. District Administrative Authority permits me to join duty as a Tahsildar, grade 1 at Kalaburagi Tahsil Office. My Lord will find page number 111.
Yeah, you were working as Tahsildar Kalaburagi.
Yes.
You were disturbed.
She has been transferred. Against that vacancy, I am posted.
Yes.
My Lord,
By the same order, you have been transferred.
Yeah.
To which place?
My lord, posting was not given by this order, my lord.
Where is that order?
My lord, page number 106, serial number 11, my lord. Financial Tahsildar grade 2. Prastutha Niyojane ಮೇಲೆ.
Nagamma K. Ravara
Yes,
Sthalake.
Yes, my lord. No posting is given to Nagamma. Therefore, my lord, I have approached my lord the honorable tribunal,
Yes.
challenging this order.
Yes.
And I joined duty as Tahsildar grade 1 on 1/8/2024. And district authority has permitted me to join duty.
On 13/8/2024, order has been passed by the KAT. Setting aside that order.
This order is challenged.
Impugned order, isn't it?
Yes.
Yes.
And after my lord challenging again on 1/8, this incumbent was transferred to Kalaburagi DC office as a leave reserve. Protocol Tahsildar. Protocol Tahsildar that has been challenged in application number 20857 of 24.
Page 40.
40. Same day, that is 1/8.
1/8, my lord. I joined there. Authorities have issued a transfer order to her as a protocol officer, Tahsildar, Kalaburagi district DC office. That she has challenged in application number 20857 of 24. That is clubbed along with the earlier application. My lord, thereafter, my lord, after the order is issued, I continue to function as a Tahsildar grade 1 of Kalaburagi Tahsil office.
Yes.
My lord will find annexure H, page number 148. My salary slip is attached. Thereafter, my lord, annexure J I have filed.
Yes.
Where I have been made a member of the several committees.
What is the finding of the tribunal?
Tribunal must set aside the order of the transfer.
Yes.
Yes.
What grounds? When were you posted as Tahsildar Kalaburagi?
My lord, on 28/7/23.
28/7/23. 2023.
Yes.
And what is the minimum term?
2 years.
2 years.
Yes.
So your main contention was premature transfer.
Premature, and I am the Tahsildar grade 1. He is Tahsildar grade 2. And the post, my lord, which I held, my lord, is Tahsildar grade 1. He, my lord, being the lower cadre, my lord, he has been posted to the higher cadre. And my lord, I have been posted to, my lord, Tahsildar grade 2 in the office of Deputy Commissioner Gulbarga. It is to the lower cadre. On these two grounds, my lord, both the applications were allowed.
Yes. Yes.
And I approached this honorable court, having suffered the KT orders. This honorable court has granted me status quo. And from August till today, I'm functioning as a Tahsildar grade 1 in Tahsil office based on the status quo order of this honorable court.
ಏನು ಸ್ಟೇಟಸ್ ಯಾವಾಗ ಕೊಟ್ಟಿರೋದು?
110 ಕೊಟ್ಟಿದ್ದಾರೆ. 110.
110.
Yes. August, September, October, even
110.
Yes.
But 13/8/2024 order was passed by CH.
Yes, that I have challenged. Immediately I have challenged, but it was,
ಆದ್ಮೇಲೆ ಏನಾಯ್ತು? What happened after that?
My lord, before the honorable tribunal, my lord, when I, my lord, got the interim order of status quo, by that time, my lord, he assumed the charge. I have not given, my lord, charge. He assumed the charge. By virtue of that, my lord, he continued, my lord, till disposal of the application, my lord, as a Tahsildar, my lord. Then after dismissal, my lord, allowing the applications, immediately he called in question, my lord, in this writ petition, and this honorable court, my lord, again continued, my lord, the status quo order.
So which means he continues as Tahsildar Kalaburagi.
Yes, my lord.
Yes. Yes.
yes, based on that, my lord, I am now, even today, I am functioning as a Tahsildar grade 1.
But what is wrong in the impugned order?
Not, I was on the waiting period for the last 7 months.
ನಿಮ್ದು ಇರ್ಬೋದು sir.
Yes.
His contention is
Yes,
that premature transfer.
yes,
You are not Tahsildar grade 1.
yes, ma'am.
So you could not have been appointed there.
Yes, yes,
These are the main contentions.
yes.
So what is wrong in the impugned order?
The government, my lord, there is a circular. Whenever there are complaints against the officials, district head should report to the government about those officials, and they will take action as per the policy decision of the government. And their duty is only to transfer without going for suspension or any. If severe charges are there, it will be suspended.
Where do you get all this?
I have filed it, my lord. I will produce. I will submit to my lord. Kindly turn to page number 112.
And there is no approval taken from the chief minister.
For?
There is no approval taken from the chief minister
About what, my lord?
for this premature transfer.
That is a regular transfer. 31/7, that was a regular transfer.
Huh?
That was a regular transfer. 31/7/2024 was a regular transfer. Premature transfers takes place in between.
That is what he is alleging. She was transferred to that place on 28/7/2023.
Yes.
2 years minimum term.
Yes.
The order has been passed, but transferring within the prescribed period of 2 years.
True, my lord. True. If there are any complaints against the officers, district head.
No such thing is reflected in the order, sir.
Agreed. But my lord,
There is
circular I have produced.
Nothing wrong in the impugned order then. You will have to convince this court what is wrong in the impugned order. Anta.
May I submit page number 112, 112. I am permitted to read.
Yes.
ದಿನಾಂಕ may I read, my lord? ದಿನಾಂಕ 8/7/24 ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಯವರ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ರಾಜ್ಯದ ಎಲ್ಲಾ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಹಣಾಧಿಕಾರಿಗಳ ಸಭೆ ನಡೆಸಲಾಯಿತು. ಸದರಿ ಸಭೆಯಲ್ಲಿ ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಗಳು ಜನರ ಸಮಸ್ಯೆಗಳಿಗೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಸಕಾರಾತ್ಮಕವಾಗಿ ಮತ್ತು ಗುಣಾತ್ಮಕವಾಗಿ ಇತ್ಯರ್ಥಪಡಿಸಲು ಹಾಗೂ ಜಿಲ್ಲಾ ಮಟ್ಟದಲ್ಲಿ ಯೋಜನೆಗಳ ಪರಿಣಾಮಕಾರಿಯಾಗಿ ಜಾರಿಯಾಗುವಂತೆ ಸಮನ್ವಯತೆ ಸಾಧಿಸುವಂತೆ ಕ್ರಮ ಕೈಗೊಳ್ಳುವ ನಿಟ್ಟಿನಲ್ಲಿ ತಮ್ಮ ಅಧೀನ ಅಧಿಕಾರಿ ಸಿಬ್ಬಂದಿಗಳಿಗೆ ಸೂಕ್ತ ನಿರ್ದೇಶನ ನೀಡುವಂತೆ ಸೂಚಿಸಲಾಗಿದೆ. ಅಲ್ಲದೆ ಕಚೇರಿಯಲ್ಲಿ ಉತ್ತಮ ಕಾರ್ಯಕ್ಷಮತೆ ಶಿಸ್ತು ಪಾಲಿಸುವಂತೆ ಕ್ರಮ ವಹಿಸಲು ಮತ್ತು ಒಂದು ವೇಳೆ ಈ ದಿಶೆಯಲ್ಲಿ ನಿರ್ಲಕ್ಷ್ಯತೆ ತೋರಿದ ಅಧಿಕಾರಿ ಸಿಬ್ಬಂದಿಗಳ ಮೇಲೆ ನಿಯಮಾನುಸಾರ ಸೂಕ್ತ ಶಿಸ್ತು ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಸಹ ಸೂಚಿಸಲಾಗಿದೆ. ಯಾವುದೇ ಅಧಿಕಾರಿ ನೌಕರರ ಬಗ್ಗೆ ಅಸಮರ್ಥತೆ ಅಥವಾ ದೂರುಗಳು ಇತ್ಯಾದಿಗಳ ಕಾರಣದಿಂದ ಅವರನ್ನು ವರ್ಗಾವಣೆ ಮಾಡಲು ಅಥವಾ ನಿಯಮಾನುಸಾರ ಶಿಸ್ತು ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಅಗತ್ಯವಿರುವ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕಳಿಸುವಂತೆ ಸೂಚಿಸಿದೆ. ಹಲವು ಅಧಿಕಾರಿಗಳು ಮತ್ತು ನೌಕರರು ಒಂದೇ ಕಚೇರಿ ಅಥವಾ ಒಂದೇ ಸ್ಥಳದಲ್ಲಿ ಅವಧಿ ಮೀರಿ ಕೆಲಸ ಮಾಡುತ್ತಿರುವುದು ಅಲ್ಲದೆ ಇಂತಹ ಹಲವು ಅಧಿಕಾರಿಗಳು ನೌಕರರುಗಳ ವಿರುದ್ಧ ದೂರುಗಳು ಸಹ ಸ್ವೀಕೃತವಾಗಿರುವುದು ಸರ್ಕಾರದ ಗಮನಕ್ಕೂ ಬಂದಿದೆ. ಆದ್ದರಿಂದ ಒಂದೇ ಹುದ್ದೆ ಸ್ಥಾನದಲ್ಲಿ ಅಥವಾ ಒಂದೇ ಸ್ಥಳದಲ್ಲಿ 5 ವರ್ಷ ಮೀರಿ ಮುಂದುವರೆದಲ್ಲಿ ಮತ್ತು ಅಂತವರ ವಿರುದ್ಧ ದೂರುಗಳು ಏನಾದರೂ ಇದ್ದಲ್ಲಿ ಅವರ ಅಧಿಕಾರಾವಧಿಯು ವಿವರಗಳೊಂದಿಗೆ ವಿವರವಾದ ಪಟ್ಟಿಯನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಕಳುಹಿಸಲು ಸೂಚಿಸಿದೆ. ಇದನ್ನು ಆದ್ಯತೆಯ ಮೇರೆಗೆ ಎಂದು ಪರಿಗಣಿಸುವಂತೆ ಕೋರಿ.
It's a general order.
This is the order.
It's a general order.
Yes, general order.
Yes,
And it is not reflected in the transfer order.
yes.
I have been transferred. As per the transfer order, I have joined. Authorities have permitted me to join. And after suffering, I approached this honorable court. This honorable has granted me status quo. Even today, my lord, pay slips are also there for the month of October and September and kindly.
So
August
you are-
already
you
I
are
filed.
not able to substantiate as to what is wrong in the impugned order. We'll have to consider, sir, whether there is anything wrong in the impugned order.
Government only has to.
That is how we'll have to consider.
Government only has to.
Yes. You want to add anything?
That's all.
Huh? That's all.
And it is reliably learned that she has reported the government for posting. The pay slips for the month of September and October.
The petitioner is aggrieved of the impugned order dated 13th of August 2024, passed by the Karnataka State Administrative Tribunal, Kalaburagi bench in application numbers 20818 of 2024, clubbed with 20857 of 2024. Stop. Next para. The fourth respondent herein had filed these said two applications before the Karnataka State Administrative Tribunal, being aggrieved of the transfer orders dated
31/7.
2024
and 1/8/24.
and consequential order dated 1/8/2024, whereby the petitioner herein took charge as Tahsildar grade 1, Kalaburagi.
Yes.
And at the same time, the fourth respondent herein was posted as Tahsildar, protocol,
Protocol test.
Kalaburagi.
Yes.
Full stop. The fourth respondent contended before the tribunal that she was posted, she was transferred and posted as Tahsildar grade 1, Kalaburagi on 28/7/2023, and before the minimum term of 2 years would elapse, orders of transfer were passed on 31/7/2024. Stop. It was also contended that the petitioner herein is grade 2 Tahsildar, and the post where the fourth respondent herein was working was grade 1 Tahsildar. And therefore, the petitioner herein could not have been transferred and posted at the place where the fourth respondent was working. Full stop. The next para. The Karnataka State Administrative Tribunal upheld the contentions of respondent number 4 that disturbing a government servant without providing postings is illegal. Full stop. Posting a government servant to a place of another government servant without there being any transfer or posting given to the said person is also illegal. Full stop. The tribunal noticed that this court had held in several cases that mentioning the name in the order or direction to report before the concerned authority to get posting is not a transfer order. Full stop. It was also held that posting of the fourth respondent herein as protocol Tahsildar is a temporary post created for 2 years.
And which is grade 2 postman.
And it is grade 2 Tahsildar, while the fourth respondent herein is a grade 1 Tahsildar. Full stop. The tribunal, therefore, held that the post of protocol Tahsildar is a grade 2 post meant to be filled by a person who holds a grade 2 Tahsildar post, and on the other hand, if a grade 1 Tahsildar is posted to such post, it would amount to demotion, and it would affect the service conditions of the fourth respondent, which would not be permissible. Stop. Having regard to the judgment passed by this court in the case of Shri T. Sunil Kumar versus State of Karnataka, reported in ILR 2013 Karnataka 4564, where it was held that if the court comes to conclusion that the order issued is contrary to law, and it should put back the person to the original position, then courts should necessarily issue such orders. Full stop. Accordingly, the tribunal has passed the impugned order, setting aside the transfer order dated 31/7/2024 insofar as the parties before the court are concerned. Full stop. The tribunal has directed that the fourth respondent is entitled to continue as grade 1 Tahsildar, Kalaburagi Taluk, till her transfer is necessitated in accordance with law. Full stop. It is also directed that the respondent state is permitted to provide separate posting to the petitioner herein without loss of time. Full stop. Next para. Learned counsel for the petitioner, however, submitted that this court passed an order on 1/10/2024 directing maintenance of status quo till the next date, making it clear that the order is open for variation upon submissions by the state as well as respondent number 4. Full stop. Learned counsel would therefore submit that the tribunal has not taken into consideration the fact that the tribunal itself had earlier passed an order in favor of the petitioner herein in Elri order
page number 101.
Application number 20517 of 2024, dated 24th of June 2024. While directing the respondent state to consider the representation given by the petitioner on 19/10/2023 to permit the petitioner to join as the secretary to the Kalaburagi Urban Development Authority in terms of notification dated 11/10/2023. Full stop. However, instead of permitting the petitioner to be to join duties as secretary of the Kalaburagi Urban Development Authority, notification was once again issued on 31/7/2024. Posting the petitioner as Tahsildar grade 1, Kalaburagi. Full stop. learned counsel would therefore submit that for no fault of the petitioner is now being penalized, although transfer orders were passed on 11/10/2023. Posting the petitioner herein, who was then working as the Tahsildar grade 2 at Lakshmeshwar, to be posted as Secretary, Kalaburagi Urban Development Authority. Stop. It was pointed out that in terms of the notification dated 11/10/2023, where the petitioner was transferred as Secretary, Urban Development Authority, was required to
Page number 93. 94, page item number 24.
report to the Urban Development Department, and accordingly the petitioner
Represented on 1910.
gave a representation on 19/10/2023 to the Principal Secretary, Urban Development Department, seeking permission to take charge as the Secretary, Urban Development, Kalaburagi Urban Development Authority. Full stop. Despite
Followed by district right.
the petitioner following all the requirements of law, permission was not given to the petitioner to take charge as the Secretary, Urban Kalaburagi Urban Development Authority. Full stop. On the other hand, one more transfer order was passed on 31/7/2024, posting the petitioner as Tahsildar grade 1, Kalaburagi. Full stop. Next para. ಇವರು ಪ್ರೋಟೋಕಾಲ್ ತಹಸೀಲ್ದಾರ್ ಅವ್ರನ್ನಲ್ಲ. Next part. You have heard the learned counsel for the petitioner, learned counsel for respondent number 4, learned government advocate for the respondent state, and perused the petition papers. Full stop.
Not she has reported the government for posting, giving a post.
No, not report.
Aviator respondent has approached the government for giving a posting.
No, my lord.
My submission may be recorded. It is reliable.
ಅಲ್ಲಿ ಅವರ ಇದು submissions ಅಲ್ಲಿ the learned counsel would also add that the fourth respondent has requested
Already approached the government.
the government to give her a posting.
Yes.
Okay. Having regard to the facts narrated herein above, it is clear that the fourth respondent raised two strong grounds before the tribunal. Full stop. She contended that since her earlier posting orders were issued on 28/7/2023, and the minimum tenure in the said post was 2 years, she could not be disturbed till completion of the said minimum tenure. Full stop. Secondly, it was contended that the petitioner herein was admittedly a grade 2 Tahsildar, and therefore he could not be posted as grade 1 Tahsildar at Kalaburagi. Full stop. This court is of the considered opinion that along with the grounds on which the tribunal has passed the impugned order, the fourth respondent is also right in her contention that the respondent authorities have not followed the requirements of the transfer guidelines dated another
25/6/24.
2013 the transfer
New transfer guide. ಇದು ಈಗ latest ಬಂದಿದೆ.
ಆಗಿದೆಯಾ?
This is applicable to this. 25/6/24.
25/6/2024. Full stop. It is also noticeable that no prior permission or consent of the Honorable Chief Minister has been taken insofar as the disturbance of the fourth respondent is concerned, having regard to the fact that
Swami, sorry.
the authorities knew.
Sorry, ma'am. Permission is taken. Kindly turn to page number 109.
ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಯವರಿಂದ ಅನುಮೋದಿತ.
Approved by Honorable Chief Minister.
ಅಲ್ಲ, you'll have to say this court has held that the order of the Chief Minister should contain the reasons.
ಇಲ್ಲಿ ತಾವು ಹೇಳಿದ್ದಕ್ಕೆ ಇಲ್ಲಿ ಹೇಳೋದು. This transfer order is approved by the Honorable Chief Minister.
ಏನ್ ಹೇಳಿದೆ? Having regard to disturbance of the I'll stop now. However, at this juncture, learned counsel for the petitioner has drawn the attention of this court to the notification dated 31/7/2024, wherein it is stated that the notification has been approved by the Honorable Chief Minister. Full stop.
And one more, kindly, I'm sorry, last paragraph of the same order, 109, page number 109, last paragraph. ಈ ಆದೇಶದಿಂದ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೆ ಬರಲಿರುವ ಅಧಿಕಾರಿಗಳು ಮುಂದಿನ ಸ್ಥಳ ನಿಯುಕ್ತಿಗಾಗಿ ಕಂದಾಯ ಇಲಾಖೆ ಸೇವೆಗಳು 3 ಶಾಖೆಯಲ್ಲಿ ಕಾರ್ಯವರದಿ ಮಾಡಿಕೊಳ್ಳುವಂತೆ ನಿರ್ದೇಶನ ನೀಡಲಾಗಿದೆ.
We are, however, not impressed
ಇದೊಂದು ದಯವಿಟ್ಟು
of the fact that the notification dated 31/7/2024 provides that the notification has been approved by the Honorable Chief Minister. Full stop.
Those who are not posting even they can approach. Adon paragraph.
That's all right. This court, in the case of so and so, adanna aamel kodtini, has held having regard to the transfer guidelines. Dated, ಹಳೇದು ಯಾವ್ದು 2013
2013, June 2013 date.
ಗೊತ್ತಾ ನಿಮ್ಗೆ? ಅದನ್ನು ಡೇಟ್ ನೋಡ್ಕೊಂಡು.
June 13.
6/7/2013.
6/7, yes, ma'am.
6/7/2013.
Yes.
That the extraordinary powers conferred on the Honorable Chief Minister will have to be exercised sparingly with while assigning sufficient reasons for such premature transfers. Full stop. Such reasonings are not forthcoming in the notification dated 31/7/2024. Full stop. Next para. Viewed from any angle, we do not see any infirmity in the impugned order passed by the Karnataka State Administrative Tribunal. Full stop. Accordingly, the writ petition stands dismissed.
Lord, by virtue of interim order, my lord, for 3 months I am out of post, man. For computing, my lord, the next transfer, my lord, these 3 months will be computed, my lord, for 2 years tenure. Therefore, that 3 months may be excluded, my lord.
My lord, my submission, I'm not supposed to make submission still. On instruction I'm submitting. After the order of the Honorable Tribunal, Learned Service Tribunal, fourth respondent did not approach anybody, nor a representation enclosing the judgment copy of this KT. And she has gone to the government asking them to give a.
No, immediately
This
interim
is
order
my
is there, my lord, therefore she is waiting,
This is
my
my
lord.
arm instruction. Even she has not approached the district authorities with the judgment, KT judgment, that I should be given. This is my.
Work out your remedies. Yes.
Great.
Notice ತಗೊಂಡಿಲ್ಲ.
1 to 3, my lord.
Learned government advocate takes notice for 7.
1 to 3.
Seal number 36, Mahesh Patil.
Lord, challenging, my lord, the order of the KT, my lord, which is at page 56, annexure C. My lord, I'm working, my lord, as a sweeper. My lord, in the third respondent office, my lord. And my lord, earlier, my lord, the tribunal, my lord, had passed an order, my lord, which is at page.
There is no interim prayer.
Please.
There is no interim prayer.
No interim, no interim. Page 15, my lord.
Learned
Yes.
government advocate takes notice for all the respondents. Learned counsel for petitioner is directed to serve copies of the writ petition annexures on the learned government advocate.
Please.
Hearing before filing of charge. Seal number 37, Ratna Shivayogina.
Yes, ma'am.
Yes.
And 23/10/2024, madam.
That the one supermarket committee, one of the secretary is presented, my lord, in this case. My lord, the review petitions is filed, my lord, it's a pending. And we requested the registry also to communicate to your lordship to be post this case, my lord.
The respondent number 3 is present, my lord. Now he is posted to transfer to at Sirsi. That during his tenure, what he has done his duties as per the directions of this Honorable. Now he is transferred, but his name is there in this matter, my lord. He is present.
So it is in fact the second respondent. The
Yes,
deputy
my lord,
commissioner,
deputy commissioner.
who has got all the powers.
Yes.
Who have issued the orders as per the directions given by this court, isn't it?
Yes.
So it is for the deputy commissioner to answer. We'll proceed.
My lord, we are willing to pay, my lord, the review petition, my lordship is changes any view, there should not be at. And therefore, we are praise this honorable court to be a review petition has to be, that we requested to the registry to communicate the posting of the case, my lord. Any date, my lord, the same day it can be posted. Your lordship is heading with the Justice Joshi, my lord.
Yes.
So once it is then we have no options. We are undergo that. Suppose if it is a succeed, and we are going to be, the lordship view maybe depends on this review petition, my lord. So we are only praying for the review petition has to be posted, and same day we lordship may take a decision, so that we will get to the clarity, and then we are going to be review petition benefit, my lord, then the things have been different. Otherwise, we have to undergo the directions of this court. Only praying for the posting for the review petition. We requested to the registry, my lord, and once again we will request it. And any Friday lordship is convenient, or even tomorrow by 2:30, or convenient of your lordship, my lord.
All right, we'll have this matter at 2:30. I'll confirm whether can be
Please,
taken.
please, ma'am.
Pass over. We'll take it up at 2:30.
Seal number 38, admission matters. Venkatesh C. Mallabadi.
Yes, my lord, both have been concerned
Huh?
divorced and married.
Huh?
I get reliable information, they are not getting that both of them are married. I got a information. I'll confirm it and report it, my lord.
Both of them are married.
Also,
Admele.
pending of this.
Hmm.
So I will confirm and submit, my lord.
A week's time is granted at
Yes,
the
my
request of learned counsel for the appellant to file necessary
I am appealing for the respondent.
respondent, respondent to file necessary
Memos.
regarding the marital status of the
Parties.
and seek appropriate orders.
Orders.
Stop. Release this matter. ಯಾವಾಗ ಬೇಕು?
10 days.
On 14th of November.
Yes.
Seal number 39, Harshvardhan R. Mali Patil.
Yes. For admission.
Yes, my lord, this is, my lord, an issue regarding, my lord, whether a post acquisition, my lord, transferee in a land acquisition matter, my lord, is entitled to be heard, my lord, in the proceedings pertaining to determination of compensation. Here is a case where, my lord, government acquires the land. After few years, my lord, they transfer that, my lord, the project to, my lord, Karnataka Neeravari Nigam, which is also part of the government. My lord, during that process and thereafter also, my lord, the land acquisition proceedings are on, and, my lord, determinations are made on appeal, my lord. It is redetermined and enhanced. Now they file a writ petition, Karnataka Neeravari Nigam, saying that, my lord, we are also, my lord, the necessary party. Project has been transferred to us and we should be heard in the matter. That writ petition, my lord, is now allowed. Lord, your lordships, my lord, have heard this matter, my lord, at the time of granting, my lord, interim order. Your lordships made, my lord, certain detailed observations in the writ interim order as well. I'm ready with the matter, my lord.
Yes. You are ready?
Yeah, I'm ready.
Yes.
Lord, the main ground of challenge is this, my lord. The impugned order, my lord, is at page 10. Paragraph 8 and 9, my lord, on running page 21 and 22 would be relevant, my lord, where the learned single judge, my lord, has discussed and my lord answered the petition against.
So having regard to section 20
Yes,
of the Land Acquisition Act,
as amended by my lord, Karnataka
Karnataka
amendment.
amendment. Of course, in both the original provision and the Karnataka amendment, in both the provisions,
Yes.
it says notice to interested persons.
Yes,
All persons interested ಅಂತ ಕರ್ನಾಟಕ amendment ಅಲ್ಲಿ ಇದೆ. ಇದರಲ್ಲಿ all persons interested in the objection.
ಹೌದು.
So in both the provisions,
ಹೌದು.
the words employed are
Yes.
that notices will have to be issued to all interested persons.
Yes.
Yes.
This is one part, my lord. Section 20 will be one, my lord, issue which may have to be dealt by this court. And the other is, my lord, there is one judgment of 1985 by the full bench, my lord, UP Awas Yojana versus Gyan Devi.
Yes.
That is, my lord, another basis for, my lord, holding that a beneficiary can file a writ petition and it can be entertained. Lord, I would, my lord, proceed to, my lord, canvass my argument, my lord, in a.
I think there is also a recent judgment of the Supreme Court.
Yes, my lord. I have, my lord, quoted certain judgments, my lord. In fact, these judgments were earlier furnished.
ಇದು ನೈವಲಿ
Ignite, my lord, is subsequent to, that is, my lord, yes, my lord, that is. My lord, one thing is, my lord, I will concede that, my lord, is the question whether a beneficiary is a necessary party. My lord, the answer is they are necessary party. I'm not in dispute with that. I'm on a question that, my lord, whether these people who enter, my lord, the arena after, my lord, the acquisition, can they, my lord, be called as beneficiaries? This, my lord, is the issue, my lord, as per my understanding of the case, my lord. I want to canvass, my lord, on that count. My arguments will be, my lord, firstly, my lord, whether they are, my lord, necessary parties since they are not beneficiaries. My lord, my answer is, my lord, they are not beneficiaries, my lord, of the acquisition. The second question will be, my lord, if they are, my lord, beneficiaries, whether writ lies. Here is a case where, my lord, LAC, a determination is made. Thereafter, my lord, the claimants file appeal in the district judge, my lord, that was listed as, my lord, LAC appeal. There is an enhancement. The LAC part they have accepted, they have satisfied. LAC appeal part, the enhancement part, my lord, they are questioning in writ petition. That is now satisfied. Firstly, my lord, LAC and LAC appeal, the parties are the same. LAC part, my lord, they were not a party. Reference court, they were not a party. In first appellate court also, they were not a party. The only question, my lord, the first appellate court order, saying that we were required to be made as a party. The admitted, my lord, position or the facts is, my lord, 99 is the acquisition in the present case. This project was entrusted to Karnataka Neeravari Nigam in the year 2005. After 6 years of, my lord, the acquisition. That, my lord, is also admitted. They are, my lord, subsequent transferee. That part also is admitted. Lord, I have, my lord, produced the compilation. Lord, I will first address my first leg of argument saying that, my lord, they do not, my lord, constitute beneficiary of acquisition and they are not necessary parties. Their status is that of a subsequent transferee or allottee. To substantiate this, my lord, I am relying on a judgment of Honorable Supreme Court, my lord, in Satish Kumar Gupta versus State of Haryana. My compilation, my lord, page 1.
Yes.
The question that arose before, my lord, the Honorable Court is, my lord, at paragraph 2, page 2, my lord.
Yes.
Question for consideration is whether a post-acquisition allottee of land is necessary or proper party or has any locus to be heard in the matter of determination of compensation under the scheme of Land Acquisition Act. The second part, my lord, we are not concerned. My lord.
Hmm.
This question, my lord, is relevant. Post-acquisition allotee or a post-acquisition transferee. The reasoning, my lord, is at paragraph number
But,
9.
there will be a difference as to whether this respondent can be construed as an allotee.
Yes.
There is a little bit of difference
Yes, yes.
that you should admit.
True.
It is not as if the land is simply given to them. It's not like that. It's a state agency which has to implement the project.
Yes. Lord, the state agents.
Here,
Yes.
we do not know the facts of this case.
Yes.
If it is clear that he is only an allotee,
Yes.
that cannot be
Lord,
equated to
my lord, if I'm
that minor difference you'll have to bear in mind.
Lord.
And if there is something, I'm sure the learned senior counsel will point out. Yes.
Yes. Lord, my lord, understand the concern, my lord, your lordships, my lord, if I understood it rightly, my lord, your lordships want to say allotee may stand on a different footing than the transferee.
Yes.
Lord, firstly, my lord, they don't.
Transferee no aste. Merely by using the word allotee or transferee.
Nan prakar one there. The proposition is this, my lord. Somebody for whose benefit, my lord, I will put it in this way, my lord, though it is, my lord, I would put it, my lord, in a sense that a person for whose benefit acquisition is not made, a person who enters subsequently, who holds that asset or, my lord, the project subsequently, whether they can be, my lord, arrayed as a party, whether they are necessary parties. This, my lord, is the larger, my lord, question. Either allotee, transferee, or, my lord, state agency taking up, my lord, the job of the state. My lord, I would suggest.
There is a minor difference.
Yes, my lord. My lord, the difference is, my lord, that should, my lord, be held against the
State itself was the beneficiary.
How?
Earlier.
How?
The state itself was the beneficiary. The state wanted to do this project.
Yes.
Then what is this project?
This is, my lord, a medium irrigation, Amarja project. It's a irrigation, medium irrigation.
Irrigation project. So,
Lord, nange kelidre, a third party transferee is in fact, my lord, better situated than, my lord, a state agency as a transferee. Because, my lord, your lordships may see these are, my lord, orders passed after hearing and, my lord, participation of the state. It's not that, my lord, state has not participated. We have taken an ex parte order. State agency comes and says, state has participated. I'm state agency. I should also participate.
what is the position declared in a Neyveli lignite?
Neyveli lignite, my lord, a beneficiary is a required my lord, arraying of, my lord, to be heard, required to be heard. Now that proposition I'm not disputing at all. If the acquisition was at
call this Karnataka Neeravari, na?
House.
Karnataka Neeravari as a beneficiary.
How?
Is the
That's
question.
the question. Your instance mele acquisition agittu antandre, then, my lord, there is absolutely no case. I should, my lord, rest my case.
Yes.
But that is not the, my lord, scenario, my lord, here.
Yes.
Paragraph 9, my lord, page 4, running page 4. To determine the question whether post-acquisition.
My learned friend reads that, let him read para 3, because, my lord, the entire basis, as your lordship rightly says, when you say beneficiary, a beneficiary is a person who gets an allotment done under a conveyance deed. And, my lord, as your lordship saw, my lord, even in UP Awas as well as,
my lord, the way
as
I
well as
want.
in Pirappa, that was under the Industrial Development Act, when the acquisition is made and a conveyance is executed to the allotee. That is a beneficiary. I am not a beneficiary. I am an assignee under the law. My lord, that's the, my lord, that your lordships have actually argued for me.
Yes.
Lord, I would like to, my lord, present it the way I want. Paragraph 9, my lord, to determine the question whether post-acquisition allotee of land is necessary or proper party or has any locus to be heard in the matter of determination of compensation, we may refer to the scheme of the Act. The acquisition scheme of the Act. The acquisition may either be for public purpose as defined under section so and so, or for a company under part 4 of the Act, Part 7 of the Act. If the acquisition is for public purpose, the land vests in the state after the collector makes an award and possession is taken. Till the award is made, no person other than the state comes into the picture. My lord, this would be relevant. My lord. Once the land vests in the state, the acquisition is complete. Any transferee from the state is not concerned with the process of acquisition. The state may transfer the land by public auction or by allotment at any price with which the person whose land is acquired has no concern. The state may transfer the land by public auction or by allotment at any price with which the person whose land is acquired has no concern. The mere fact that government chooses to determine the allotment price with reference to compensation price redetermined by the court does not provide any locus to an allottee to contest the claim for enhanced compensation. Yes. So it says, my lord, once land vests with this, there are two modes of acquisition, my lord. One is, my lord, acquisition for public purpose. One is acquisition for company. If the acquisition is for company, Lord, as they are, my lord, now the company, it should be under Part 7 of the Land Acquisition Old Act. That provides a different set of, my lord, methodology for acquisitions. It also provides for a scenario where, my lord, the government and, my lord, the company are supposed to get into an agreement. That agreement should be published. Public, my lord, can call for objections. That's a complete set of, my lord. This was an acquisition by the state for public purpose, subsequent transfer. Now the answer to the, my lord, judgment is, my lord, at paragraph number 18 on page 7. The question raised is whether a subsequent allottee or transferee is, my lord, has any locus to be heard. The answer is at page 7, paragraph 18. Accordingly, we hold that post-acquisition allottee has no locus to be heard in the matter and is neither a necessary nor a proper party. Paragraph 18 on page 7. The question was whether a post-acquisition allottee or, my lord, a transferee has locus and he is required to be heard. The answer is, my lord, they are not necessary party. They need not be heard. Now, my lord, your lordships, my lord, rightly pointed out regarding Neville Lignite and, my lord, UP Awas. Neville Lignite was a judgment by 3 judges. UP Awas Yojana versus, my lord, Gyan Devi was a judgment by 5 judges. So, my lord, they are, my lord, in parity. That both those judgments are, my lord, dealt with and, my lord, distinguished. Neville Lignite is, my lord, in paragraph 15, page 7. It's about, my lord, 8 lines from, my lord, I'm referring to running pages, my lord. This issue had come up in this case also, my lord, saying that page 7, my lord, paragraph 15.
7.
Yes, paragraph 15. It starts with, my lord, the Himalaya tiles.
Yes.
3, 4, 5, 6, 8 line, my lord. In Neville Lignite, again the acquisition was under Part 7. Now, this is the distinction for a company of the Act. And in that context, this court held that the expression person interested would include a company or local authority for whose benefit the land was acquired. The post-acquisition allottee cannot by any stretch of imagination be treated at par with beneficiary for whom the land was acquired. This is the distinction. Subsequent transferee cannot be treated on par with the beneficiary. He doesn't have the rights of the beneficiary. In this case, beneficiary was state. State is heard, my lord. I'll further read it, my lord. This is another judgment, my lord, which they rely in support of their case. That is, my lord, in UP Awas Evam Vikas Parishad, the matter dealt with was in the context of statutory authority for whom the land was acquired, Delhi Development Authority, so was in the case of so and so. So Neville Lignite and, my lord, the UP Awas Yojana, my lord, if your lordships can come to paragraph 13 on the previous page, page number 5. This is another judgment, my lord, in their support saying that, my lord, beneficiary, The judgment in UP Awas Evam Vikas Parishad, so and so and so and so, as mentioned in paragraph so and so, judgment of Veerappa, were held to be not applicable as the same applied only when the acquisition is for a company or for the beneficiary of acquisition as mentioned in the notification for acquisition itself. So if they are mentioned as a beneficiary in the acquisition, my lord, then
That is very
these-
clear.
Yes.
Yes.
So, my lord, this is the proposition of law, my lord, insofar as, my lord, whether a post-acquisition allottee or, my lord, a transferee can plead and, my lord, contest, my lord, determination. Mine is a case where the beneficiary, that is the state, the original beneficiary, he was heard, my lord, and, my lord, the redetermination of was made. Lord, in this case, I'll just read, my lord, one more provision, my lord. The other issue that they arise is, my lord, now we are supposed to pay the compensation. Or, my lord, rightly or wrongly, any judgment that is passed, we are supposed to, my lord, answer that claim. That also, my lord, was contended here. They said that this was a case where, my lord, the agreement between the allottee and the original, my lord, beneficiary was that whatever will be the enhancement, based on that, your allotment rate will be determined. So ultimately, the allottee was supposed to satisfy the redetermined amount. Even under that context also, court held that even if that is the situation, that is between you and the agreement holder. The owner has no business with that. My lord, the idea is this, my lord. What will happen is, my lord, the land losers, if they are, my lord, asked to, my lord, start impleading persons who they are transfer. My lord, today it is with them. They may, my lord, transfer it to somebody else. My lord, we will go on with the, my lord, litigation and we will never end up, my lord, getting the compensation. Requirement of a beneficiary, my lord, that is no doubt. Post, my lord, acquisition, it's your agreement and your understanding with the beneficiary. You ask the beneficiary to contest, or you get that terms along with your beneficiary. The owner, my lord, should not be made to suffer. No, my lord, I would like to read, my lord. This was, my lord, referred before the learned single judge also. Learned single judge, my lord, understood this case in the context that, my lord, these are judgments pertaining to acquisitions under different acts, not acquisition under Land Acquisition Act. Therefore, they cannot be, my lord, considered. Paragraph 9 of the judgment, my lord. This is, my lord, the basic error, my lord, the learned single judge, my lord. The impugned judgment, my lord, is at page 10. It starts from page 10. The reference to Satish Kumar is on, my lord, page 20, Roman 1.
Yes.
The answer to those judgments is at paragraph 9, my lord.
Yes.
The decision relied by so and so are not applicable to facts of the case. Said decision. Lands were either not acquired under the Land
Are there any other judgments?
Yes.
Which were coming out of the Land Acquisition Act?
No, my lord.
According to the learned single judge.
Yes, my lord. This
In paragraph number 9.
Yes.
He says,
yes,
the judgment that you sought to rely upon
yes,
did not arise out of the Land Acquisition Act.
True, my lord.
Therefore,
yes,
were there any other judgment which the learned single judge thought will rightly apply in this case?
No, my lord. The single judge might have, my lord, taken this Pirappa case. The second judgment, my lord, he might have taken. That was a case under, my lord, KADB Act. The proposition is the same. The act is different. The proposition is
Satish Kumar Gupta
was under the Land Acquisition Act.
Land Acquisition Act.
Howdu? Idaralli Pirappa case rely madidare. Pirappa case is relied in Satish Kumar case, and my lord, they hold that even under land, because my lord, the question your lordships may see. The question for consideration is whether a post-acquisition allottee of land is necessary or proper party or has any locus to be heard.
The scheme of the Land Acquisition Act
1894. Pirappa, my lord, obviously was under KADB, but my lord, I still hold that Pirappa is also applicable because it lays down the proposition. What is the mode of acquisition hardly matters. This was one, my lord, point which missed out by the Leonard Singhal. The other point was, my lord, section 20 of, my lord, the Karnataka amendment to, my lord, the Land Acquisition Act 1894. My lord, there also, my lord, there is a different, it was wrongly understood by the law.
Old Act.
Old Act, Karnataka amendment.
Service of notice.
ಅದೇ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದಾರಲ್ಲ ಇಲ್ಲಿ.
ಅದೇ ಅದರ ಇದರಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಆಯ್ತು. I'll refer to that.
It has been extracted here.
Yes, yes.
Yeah.
Yes, I'll read that.
7.
Lord,
Both are there. Yes.
How the principal act, my lord, it says, my lord, I'll first read, my lord, the
Yes.
service of notice. The court shall thereupon cause a notice specifying the day on which the court will proceed to determine the objection and directing their appearance before the court on that day to be served on the following persons. One is, my lord, the applicant who had, my lord, sought for reference. Second is all persons interested in the objections. Third is, my lord, in the objection is regard to
Yes.
area. So and so. My lord, we are concerned with, my lord, the Karnataka amendment which replaces
Yes.
ABC by, my lord, another set of. So following persons, namely one is, my lord, deputy commissioner. Second is, my lord, all persons interested in the reference. Third, my lord, is C, if the acquisition is not made for government, the person or authority for whom it is made. So what it means is, if it is for the government, deputy commissioner. If it is not for the government, for whose benefit it is made. Clause B is a persons who are interested in the reference. My lord, they cannot be interested in the reference. Persons interested in the reference are persons who are seeking for reference and who are, my lord, seeking for relief under the reference. There is a bar for companies to seek for reference. They cannot seek for reference at all. They can only fall under clause C. Beneficiaries and, my lord, state can fall under A and C. If it is government acquisition, A will be applicable. If it is non-government acquisition, C will be applicable. Here, my lord, if they show that it is a non-governmental acquisition, then, my lord, this second proviso, the second part will, the person or authority for whom it is made. Here also, my lord, it is the persons for whom acquisition is made. So requirement, the requirement is, my lord, that it should be the person for whose, my lord, at whose instance acquisition is made. So this also, my lord, the Leonard Singhal just says, as per 20, they are, my lord, required to be heard.
Yes.
Now, my lord, in support, in addition, my lord, Satish Kumar Gupta, my lord, is the, my lord, lead case, my lord, on this proposition. Pirappa case also, my lord, is on the same proposition. If your lordships want me, my lord, I will read the relevant para, my lord, or else, my lord, I will skip that.
Yes.
Pirappa case, my lord, it starts from page 9. Paragraph
Case
50.
where the acquisition was for a company.
It was for KIDB. My lord, this was a case where, my lord, KIDB was the beneficiary. It came into, my lord, some understanding with some allottees saying that if there is increase, you are supposed to pay. Those allottees, my lord, sought into, my lord, implead themselves and, my lord, contest the claim. There they said that original beneficiary is KIDB. They are heard, finished. Any other subsequent transferee, we are not concerned.
Yes.
The owner is not concerned. I'll read, my lord, paragraph 51 and, my lord, 54, my lord. It's on page 22.
Yes.
A careful reading of the aforesaid provisions of LA Act, KIAD Act, the KIDB regulations would clearly go to show that company, that is, my lord, the allot is neither a beneficiary nor an interested person in the land, as on the date of acquisition of the land, as the land was acquired by the state government in favor of KIADB. who is the beneficiary, and it has allotted in favor of the company after the acquired land was transferred in its favor by the state government and executed lease agreement, so and so. So, my lord, the proposition is the same. Person for whose benefit acquisition is made and a transferee. Transferees are excluded from hearing. Paragraph 54, my lord, the acquisition of the land, page 22. Under the provisions of Land Acquisition Act in favor of a company, the mandatory provisions as provided under Part 7 of the Land Acquisition LA Act and rules must be adhered to. That is not the case in the acquisition of land involved in these proceedings, as the acquisition of the land is under the provisions of so and so. Therefore, the reliance placed on so and so. So, my lord, if it is under Land Acquisition Act, a company acquisition, Part 7 will be applicable. That, my lord, admittedly is not done in this case. It is never their case that the acquisition was for their benefit. Now, my lord, paragraph 60, my lord, on page 25 may also be relevant, my lord. Paragraph 60 on page 25, my lord, in the same judgment.
Yes.
I'll first read, my lord. Further, the learned single judge of the High Court has further committed an error in law in not appreciating Section 54 of the Land Acquisition Act, which provision provides the right to appeal to the landowners or state government and beneficiaries of the acquired land, but not to the company which is lessee. So, my lord, post-acquisition people do not have the right of appeal under 54. When the company does not have the right to file an appeal against the award, it also has no right to file a writ petition. So, if the 54 also provides for second appeal, if they don't have, my lord, this would be, my lord, on my first leg of argument, my lord. Second leg of argument is, my lord, the judgment of the Supreme Court, which says, even assuming, my lord, when there is, my lord, the second leg of my argument would be, my lord, whether a writ petition is maintainable. For a moment, my lord, let us assume that, my lord, they are somebody whom, my lord, the court is required to.
Depends on whether the court would be convinced.
Yes, my lord. Yes, my lord.
It is.
If I succeed in my first leg of argument, my lord, it's gone, my lord. I need not, my lord, plead. My lord, I would still address on that also, my lord.
Yes.
Or if your lordships want me, I'll do that, my lord, after it is answered, my lord, my first leg of argument. My second leg of argument is, let us for a moment assume that, my lord, they are a necessary party, they are required to be heard. Can that exercise be done in a writ petition? What has now happened is, a transferee has, my lord, put in a writ petition that is allowed. An award under, my lord, is set aside. Section 54(2) provides for, my lord, second appeal. There is a statutory appeal provided. Now the question is, what is the recourse available to them? For this, my lord, I will read, my lord, UP Awas Yojana, and, my lord, this judgment, Sachi Burdwan Development Private Limited versus State of West Bengal, page 31. The relevant para is, my lord, paragraph 8, my lord, on page 37. May I read, my lord? So far as civil appeal is concerned, so and so, writ petition and so and so for the writ. I'll read it from, my lord, the fourth line. Herein, Sachi Burdwan, my lord, this is a company, my lord, which is a subsequent transferee. Sachi Burdwan was not a party to the reference proceeding. My lord, I'm reading paragraph 8, my lord, from fourth line. Herein it starts. Sachi Burdwan was not a party to reference proceedings. The locus of the appellant, Sachi Burdwan, has been seriously disputed on behalf of the landowner claimant, and it is seriously disputed whether the appellant Sachi Burdwan can be said to be a person interested within the definition of 3B of Land Acquisition Act. It is also required to be noted that as such, out of 24 references before so and so, High Court in writ petition, the appellant restricted the prayer with respect to only 4 respondents, namely so and so in the writ petition. As observed here in above, as the instance of BDA, 4 appeals challenging the judgment and award passed by the reference court are pending before the High Court. Therefore, in the facts and circumstances of the case, and more particularly when the locus of the appellant, Srachi Burdwan, to challenge the judgment and award passed by the reference court is seriously disputed, and whether the appellant Sachi Burdwan can be said to be a person interested within the definition of so and so of the Land Acquisition Act, and thereby the appellant can challenge the judgment and award of passed by the reference court enhancing the compensation, are all disputed question of facts and are all contentious issues. We are of the opinion that learned single judge of the High Court ought not to have entertained the writ petition under 226 of Constitution of India and ought not to have set aside the judgment and award passed by the reference court, enhancing the amount of compensation under the provisions of Land Act. The remedy available to the appellant would have to be to prefer appeal before the High Court with application for leave to appeal. When, my lord, the locus is under serious contest, yes. Paragraph 9 as well, my lord, about 6 lines, my lord. I'll skip the first 6 lines. Reference court. The question is not about maintainability of writ petition. Lordship's got it, my lord. The question is not about maintainability of writ petition. The question is with respect to the entertainability of writ petition, and for the reasons stated above, we are of the firm opinion that the High Court ought not to have entertained the writ petition under 226 of the Constitution, challenging the judgment and award passed by the reference court, more particularly when the appeal would have, when the appellant would have a remedy to file the appeal under Section 54 with the leave of the court, and if at all the appellant court, High Court grants leave to prefer the appeal, challenging the judgment and award passed by the reference court. So writ, my lord, is not maintainable at all. The answer is, my lord, in paragraph 15, my lord, but the gist is that, my lord, cannot maintain an appeal. Lord, now, my lord, if your lordships can take, my lord, what is the basis for holding that, my lord, a writ is maintainable? My lord, there are 2 judgments, my lord, mainly which they rely. One is, my lord, Neville Lignite. One is, my lord, UP Awas Yojana case. UPO, I will first, my lord, go to, my lord, UP Awas Yojana case. My lord, that is not part of my compilation. They have filed it, my lord. They have filed another compilation. But not there. It's not there. It's there in their compilation. Yes. May I take to, my lord, your lordships at page number 160. 116. 160. The judgment starts with at, my lord, 142. Relevant paragraph is at page 160. 160. Yes, 160. Lord, this is, my lord, UP Awas Yojana. It starts at, my lord, page 142. Paragraph 22, my lord, deals with, my lord, what should happen. My lord, this is a comprehensive, my lord. The subject is dealt in comprehension, what should happen and what stage, what happens, and what should be the my lord, possible release that the party has. Paragraph 22 would deal with a situation where, my lord, a reference court award is passed or an appellate court award is passed, and, my lord, what should be done by the party, my lord, who seeks to be a beneficiary and who is not arrayed as a party. In case the amount of compensation has been enhanced by the court and no appeal is filed by the government, the local authority, if adversely affected by such enhancement, may file an appeal with the leave of the court. This right of the local authority does not depend on it being impleaded as a party in the proceeding before the reference court. Even if the local authority is not impleaded as a party before the reference court, it can file an appeal against the award of reference court in the High Court after obtaining leave if it is prejudicially affected by the award. In case the government files an appeal against the announcement of award, the local authority is entitled to support the said appeal and get itself included as a party. When the person having an interest in the land files an appeal in the High Court against the award of reference court and seek enhancement of amount of compensation, the local authority should be included as a party in the said appeal, and it is entitled to be served with notice of the said appeal so that it can defend the award and of the reference court and oppose the enhancement of the amount of compensation before the High Court. The same will be the situation in case of an appeal to this court from the decision of the High Court. The conclusions are, my lord, listed in, my lord, paragraph 20. And 54 also has, my lord, Karnataka amendment, which provides for second appeal. Before 2 will be applicable. my lord. An order in appeal can be challenged.
At
my lord.
best, MFA,
MSA, my lord. Miscellaneous second appeal is.
second appeal, because there is a
There is
first
a
appeal already.
order is there. So 54-2, my lord, second appeal is maintainable.
Yes.
The conclusions are, my lord, listed at paragraph 24. But where the court erred was, my lord, regarding maintainability of writ petition. This judgment, my lord, answers writ is maintainable, definitely. In respect of, my lord, firstly, he should be a beneficiary. This was a case where the beneficiary was, my lord, challenging, not the transferee. So, my lord, I'm assuming that they are, my lord, beneficiary. So, if they are beneficiary, they can challenge certain proceedings in writ. That is, my lord, listed at item paragraph 24 is item 1, 2, 3, 4, and 5, 6, my lord. 1 to 6, my lord, they deal with a situation where, my lord, they can file a writ. 7 is, my lord, relevant and, my lord, applicable for the present case. 7 is an event. There is a situation where, my lord, I'll just read that, my lord. In the event of enhancement of amount of compensation by the reference court, if the government does not file an appeal, the local authority can file an appeal against the award in the High Court after obtaining leave of the court. So if there is a determination by the reference court or B, my lord, the first appellate court, this will be the situation. And that too, my lord, in a situation where government doesn't file. If they file, they can implead and, my lord, they can test, they can support the government or, my lord,
Not filed. State has not filed.
state has not filed.
Yes.
The other situations are, my lord, situations where either the reference is still pending or, my lord, the stage is at the hands of, my lord, the collector where he is yet to pass an award under section 11. If their, my lord, beneficiary is not heard, they can implead, they can seek for impleading. Impleading is rejected, they can file a writ petition. Even the award of the collector, they can call it in question in 226. If reference my lord, court rejects their application to, my lord, come on record, then also, my lord, they can come into it. Once the reference court passes an award, it seizes or, my lord, determines an award, there is a provision for appeal. Then, my lord, the only relief as per this judgment also is to file an appeal. This distinction, my lord, is not made by the learned single. Yes. Now, my lord, the other judgment, my lord, which is heavily relied by the, my lord, respondent is, my lord, that heavily lignite case, my lord. That's, my lord, in the compilation at page number. It starts from page 130, my lord. One 130, my lord. It starts from 130. Relevant portion is at page 140. The compilation of the respondents is the one we look. E case alli, again, my lord, the beneficiary for whose benefit it was acquired, my lord, they have challenged that. Here, my lord, what they did was paragraph 15, if your lordship sees, they contested by filing a appeal. Sorry, they contested by filing a writ petitions. Honorable Supreme Court, my lord, again held that, my lord, this has to be treated as, my lord, an appeal. Paragraph 15, I will read, my lord. I'm reading paragraph 15 from 140. Since the writ petitions filed by the appellants were dismissed, we set aside the orders and direct the High Court to treat them as appeals properly filed under Section 54 of the Act and be dealt with along with the appeals filed by the state pending disposal of the High Court in the pending reference, so and so, so on. So even in heavily lignite also, my lord, they held writ is maintainable, but they, my lord, converted them or, my lord, they directed the, my lord, High Court to treat them as an appeal. So ultimately, both these judgments say the recourse is only under appeal. Yes. Yes, yes. Lord, this is, Lord, my second leg of argument saying that, Lord, writ petition is not maintainable. Lord, third leg of my argument is, Lord, even if it is maintainable, Lord, for a moment, assuming they are beneficiaries, writ is maintainable, then, Lord, blanket remand, Lord, is not permissible. Lord, similar situation arose before this court, Lord, in MFA number 3212, page 40, Lord, of my compilation. The judgments, my lord, I have furnished. Not that one, my lord, the one below the compilation. Yes. Page 40, my lord. This is by the division bench of this court. This was a situation where, my lord, a beneficiary, that is, my lord, Karnataka Housing Board, they, my lord, did not participate in the proceedings of redetermination. State participated and, my lord, the state suffered an order. After that, my lord, when it came to, my lord, paying compensation, they come up and say, my lord, we were not arrayed as a party. So, my lord, the court deals and, my lord, makes an observation regarding this kind of practice, my lord. Read it from, my lord, paragraph 23 on page 56. Paragraph 20, while it may be more prudent to understand that a beneficiary also can be included within the meaning of person interested as is it accrues in so and so, the mere ipsi dixi of a beneficiary that they were not made party before the land acquisition officer or the reference court, whether carries conviction or not, and many a times made without any bona fides and coming up with such grievance after long lapse of time, should be a matter of examination by the court and cannot be a justification for setting aside or disturbing the judgment of the reference court solely on the ground that beneficiary has not been given an opportunity. So even if they are not given an opportunity, their necessary writ is maintainable. Court is still required to, my lord, see whether they have something on the case which would alter, my lord, the award. Paragraph 25, my lord. When the very purpose of acquisition is notified to be for public purpose, namely for construction of so and so, by the present appellant beneficiary, the Karnataka Housing Board and Housing Board is quite aware of the development. Even assuming they are not notified, it was their duty to follow up and to have volunteered to participate not only in the proceedings before the land acquisition officer, but also in the further reference before the civil court, wherein the land acquisition officer, an employee of the state government who acts as a statutory functionary, is implicated as a respondent. The beneficiary, like the board, finges ignorance of the proceedings and seeks for annulment of the judgment of the reference court, calling in aid the administrative law principle. Such a violation of principle of natural justice is, in our view, nothing short of a contention lacking conviction and bona fides. Paragraph 24 also, my lord, they have dealt with, my lord, these situations and, my lord, the pain of the land losers. 324 as well, my lord. We say so for the reason that while length of litigation is probably long in our land, and litigation in our legal system can easily last generations together. A poor landowner whose land who loses his land because of compulsory acquisition being made to wait endlessly to receive a just compensation for his land acquired by the state, and such determination being postponed due to one technical reason or the other, and such matters making their journey from the reference court to the high court and back to the reference court and again to the high court and then to Supreme Court. Thereafter, a reverse journey to the high court is nothing but a hazardous and arduous journey for the landowner and harassment from the highest order due to the existing legal system. Lord, what I would, Lord, take from this judgment is, Lord, even if they are, Lord, necessary and, Lord, they are required to show that, Lord, their participation would have made a difference to the award. So, my lord, blanket remand, my lord, should not happen. This is, my lord, my third leg of argument. Still address on, my lord, merits of the case as well, my lord, that I would, my lord, reserve, my lord, subject to, my lord, they answer this. All right. We'll continue at 2:30.
Next week, man. Serial number party.
We'll see at 2:30.
Yes.
Sequence.
Court officer.
ಹೇಳ್ರಿ
Court officer.
ಹೇಳ್ರಿ ಸರ್.
Serial number 53 ಏನಾದ್ರು ಅರ್ಜೆಂಟ್ ಆಗಿದ್ಯಾ?
ಅರ್ಜೆಂಟ್ ಆಗಿಲ್ಲ.
ಹಾ?
ಆಗಿಲ್ಲ ಸರ್.
ಆಗಿಲ್ಲಲ್ಲ?
ಇಲ್ಲ ಸರ್.
ಓಕೆ.
May I seek liberty, my lord.
Huh?
May I seek liberty, my lord. Review petition, my lord, 2 review petitions. But I went to ARJ office, my lord. But he is informed to move before lordship only, my lord. That's why. Tomorrow, my lord, 2:30, my lord, if it is possible.
I forgot to ask my brother judge. After the court hours, I will consult him and then fix a date.
Yes.
Huh? We'll have it later.
Please. Shall I give my lord to the court officer? my lord?
Forty.
Please.
Yes.
The
Continue.
C number 39.
the last point of my lord argument is, my lord, the Neeravari Nigam through its officer, that is my lord special land acquisition officer, is already represented, and my lord, they are heard in the matter. Lord, they are now trying to, my lord, disown, my lord, the special land acquisition officer, and they want to say that, my lord, he belongs to the state, we are a different entity. Your lordships may kindly take, my lord, my writ appeal.
Yes.
Page 51, my lord, the impugned judgment which was, my lord, called in question in the writ petition. Page 49, my lord, is the impugned judgment award which was called in question in the writ petition. 49, it starts, my lord, the relevant page is 51. The first party is, my lord, Special Land Acquisition Officer, M and MIP. M and MIP stands for, my lord, Minor and Medium Irrigation Project, Kalaburagi. Now, your lordships may kindly turn to, my lord, page number 76. What's the, my lord, the question is, my lord, whether they are part of the government or not. If they are part of the government, my lord, Deputy Commissioner will take care. My lord, they need not be, my lord, read separately. 76, my lord, is the organizational chart of Water Resource Department of the Government of Karnataka. Now, this is, my lord, still existing in the website of the Lord, your lordships is, my lord, it is headed by the minister, my lord, and my lord, the fourth column. The functioning of this department is through, my lord, 3 companies. One is, my lord, Karnataka Neeravari Nigam, by managing director, the then managing director, my lord, so and so.
Yes.
Second one is Krishna Bhagya Jala Nigam Limited. Third is Kaveri Neeravari Nigam Limited. These people and, my lord, the institute which has now called in question, the company which has called in question, is, my lord, directly under the control, and, my lord, it is part of the state. It is functioning under, my lord, it has no independent identity other than the government of Karnataka. They are functioning, my lord, as agencies or, my lord, officers or authorities under the state. This is the organizational chart. The lordships may come to, my lord, page 79. Page 79 is a judgment, my lord, not related to this, my lord. This is a case where, my lord, the government and, my lord, Nigam acting, my lord, as one entity files, my lord, appeals. First is, my lord, State of Karnataka through Land Acquisition Officer, M and MIP, the same officer. Second is State of Karnataka through Executive Engineer, KNNL, IPC, that is, my lord, Irrigation Project Zone, Abjalpur. My lord, it is this officer, Executive Engineer, KNNL, who is, my lord, the petitioner in the present writ petition, which is, my lord, now called in question. He wants to say, I'm an independent agency, I'm not state. And all these persons, my lord, are represented by the government advocate. This is not one judgment, my lord. I have produced, my lord, series of judgments. 81 R4 to R6, up to R6. So several judgments are, my lord, my lord, the proceedings are initiated, holding them that, my lord, they are both inter se, my lord, one and the same, and they are represented by, my lord, the government advocate. Here also, my lord, the SLO is represented by the district government leader who is supposed to take care of the Now, my lord, your lordships may kindly turn to one compilation filed by them, my lord, yesterday. It's my lord, dated 4/11/2000. 4/11/2024. They're all typed copies, my lord, which I believe to be true, my lord. Page 1, my lord, is the proceedings where government of these are, my lord, documents filed at the order of, my lord, the court. Earlier there was an order to file, my lord, these, my lord, matter. These are, my lord, their compilations. My lord. Page 1, my lord, is the proceedings of government of Karnataka, where this project is handed over to, my lord, the Karnataka Niravari Nigam. Lordship may turn to, my lord, page 3. The date is, my lord, 11/4/2005. Acquisition in the present case is, my lord, 1999. So 6 years later, my lord, it is transferred. My lord, I would like to highlight, my lord, page number 8, my lord. Page number 8, annexure C. Lord, this is the letter of, Lord, the Special Land Acquisition Officer. Lord, it's stated in the bottom, signed so and so, M and small and medium irrigation projects. To, Lord, the Chief Administrative Officer, Karnataka Niravari Nigam. Lord, this is, Lord, a request letter by the SLO to the Nigam asking to release the amounts in LAC pertaining to the very same award. What is now questioned in writ petition is an award in LAC appeal, the first appellate court award. These are, my lord, amounts satisfied by the Karnataka Niravari Nigam, even when they were not parties in the LAC. In reference court, my lord, they accept that, my lord, they are not a party, but will satisfy. The appellate court award, my lord, they contest that we should have been made a party. This was a request made by the SLO to, my lord, the chief officer. Second, my lord, page 9 is the letter written to, my lord, SLO, saying that, my lord, they have released the amount. Just read, my lord, the 2 paragraphs. With reference to the above, my lord, these pertain to the very same, my lord, set of cases. With reference to the above subject, an amount of so and so towards payment of bills relating to land acquisition cases has been released to your current account dated so and so. Accordingly, you are instructed to take the action to deposit the deposit in the court with suitable appeal to completely close the EPs registered in the case, said cases, and action to be taken to instruct the advocate of the concerned corporation to file suitable application before the court to completely close the LAC cases and submit the report to in this regard. So, my lord, this concerned advocate is the DGP. Instructions are given to SLO. Now, my lord, your lordship may come to, my lord, annexure E, page 11. Lord, this is a letter. Lord, what I'm trying to put forth is they are, my lord, instructing the council through, my lord, SLO. It is their council only. So they had that representation. That is what I'm trying to. Page 11, my lord, is, my lord, the letterhead of the, my lord, Niravari Nigam. They have not, my lord, shown that on the this thing. My lord, your lordship may see right-hand side, my lord, Office of the Special Land Acquisition Officer, Karnataka Niravari Nigam Limited, Bennetora Project, Kalaburagi. So, my lord, it is this party, my lord, who is already there in the my proceedings. He was heard, he has contested, he has lost. He writes a letter to, my lord, the Chief Administrative Officer of Karnataka Niravari Nigam under the, my lord, heading and letterhead of, my lord. I have other letterheads. I don't know why it is not shown, but the letterhead is, my lord, Nigam. It says, my lord, for release of amount. This is in respect of the present batch of, my lord, awards which are set aside.
Yes.
It is signed by Special Land Acquisition Officer KNNL Bennetora. So, my lord, the officer, Special Land Acquisition Officer, who had the title of M and MIP, because, my lord, that time the a designation was minor and medium irrigation. He now writes, my lord, himself, or designates himself as, my lord, Special Land Acquisition Officer, Karnataka Niravari Concerned Project. So the officer is the same. He works under, my lord, the letterhead and, my lord, the instructions of the Karnataka Niravari Nigam. So they cannot, my lord, say that we were not heard in the matter. It's a different aspect that he might not have taken care of, but that's a. So, my lord, the last leg of my argument is state and Niravari Nigam is one and the same. They cannot seek, my lord, any exclusivity or, my lord, differentiation from the Nigam. It's an illusion created just to, my lord, overcome these awards. And leave, my lord, I want to quote, my lord, one single judge, my lord, order as part of the bench, my lord, where this issue had risen and, my lord, the view is taken. Sorry. This issue, my lord, had come up, my lord, when it was before the single judge, my lord. The page 4, my lord, paragraph 5(1). The question, my lord, which is now involved, whether the appeal, my lord, there was a case where, my lord, the appeal was filed by the claimant and, my lord, Nigam was not a party. State contended that Nigam is a necessary party. Appeal cannot proceed without the Nigam. It's also, my lord, this is also Benetora project. So the question there arose was whether the appeal is maintainable in the absence of Karnataka Niravari Nigam Limited as party to the proceedings. The answer is in the negative. The reasoning, my lord, is at paragraph 7. Considering, my lord, the Satish Kumar case, my lord, which I first quoted. It is held that, my lord, the Karnataka Niravari Nigam, which is a post acquisition wherein it is observed that post acquisition allottee has no locus standi to be heard in the matter. It is neither a necessary or nor proper party. In view of the aforesaid finding, they consider view that at this stage Karnataka Niravari Nigam is not necessary and proper party to this proceeding. Accordingly, I answer so and so. Yes, I'm not holding this, my lord, against, but, my lord, it is my duty to bring it. On merits, my lord, I would submit, my lord, if required.
Yes. May I please, your lordship? Lord, I'll supplement the reasonings which the learned single judge has given. Your lordships have seen that, so I will not trouble your lordship with that. So I just wanted to give a brief overview as to why we are here. My lord, in many matters, I'm told there are about 2,000 writ petitions pending before the learned single judge filed by us, where, my lord, the challenge is to orders passed in appeal under 54 without making the Nigam a party. Now, what is happening here is, my lord, we are not made parties. The government is made a party. The government contests the matter. But when it comes to executing those orders, they come to us. They execute those decrees against us. So naturally, my lord, we are not aware of these proceedings, my lord. And in most of these cases, the appeals are filed after huge delays. For example, in this case, the appeal was filed after a delay of 5,207 days. And this is the trend which we have seen across the board in all these cases. So, my lord, definitely, my lord, this is a matter where your lordships, my lord, we'll need your lordship's assistance in laying down the law. And, my lord, of course, my lord, the principles of law are well settled. And today, my lord, your lordship made that very pertinent observation. That is, there is a distinction between who is a beneficiary and who, like me, my lord, my argument is going to be, there is a distinction between a beneficiary as understood ordinarily because it is not an expression defined under the law. So this is a term of usage, my lord, generally speaking, as to who is the end user. My lord, as far as somebody like the Nigam is concerned, we are what are called assignees by the government, where there is no consideration involved. So the basic principle that we need to be looking at is who is a beneficiary and who is not a beneficiary. Now, my lord, the two main judgments for the purposes of whether we are required to be made parties or not, my lord, your lordship knows, is Pirappa and that Satish Sharma's case. Now, Pirappa, my lord, I'm just broadly telling, and I'll take your lordship through those relevant judgments. Pirappa, my lord, your lordship knows, is a KIDB Act and acquisition. What did the Supreme Court do? It says that the allottee of the KIADB is not required to be a party when it comes to challenging enhancement. Why? The court says the beneficiary is allotted the land under a conveyance agreement. It could be a lease, it could be an outright sale, etc. Those documents contain a specific clause which says that you shall be liable to pay additional costs in case of enhancement, if there is an enhancement as to compensation. So the allottee doesn't pay compensation to the land loser. He pays it as an additional cost for the purpose of getting that land. And that's the core reasoning in all these judgments. Now, that is distinct from an exercise of executive power by the state, where the state decides to get the project managed through the agency of a government company. Now, my lord, under the scheme of the Land Acquisition Act, Part 7 does not apply to government companies. It is not treated as a company as ordinarily understood, because I'll show those provisions. My lord, the Part 7 of the Land Acquisition Act deals with incorporated private entities, not with government companies. They are excluded specifically. That is the reason why, my lord, the Act allows the government to assign it to a government entity like a government company. Now, why did the government do it? It does it because for economic necessity, because the government wants to generate funds by creating a special purpose vehicle. Now, my lord, for example, the Nigam in this case, my lord, we have, my lord, all these lands after the Nigam was incorporated. In fact, under the supervision of a division bench of this court, my lord, an elaborate exercise was undertaken for transferring and conveying the entire titles in our favor. Now, we have virtually mortgaged our entire lands to various banks and financial institutions to run these projects. Now, these are not, my lord, these are all social welfare measures, but the government needs to innovate and generate funds for running these kind of, my lord, operations. So we can't, my lord, government has its own limitations. So government thought that we will create a government company which will borrow money from the market. So that is why, my lord, these are essentially special purpose vehicles for the purpose of getting revenue so that these projects are managed and expanded, etc. All the development is done. So that's the main essence of this. And that is why the government says you are entrusted with the responsibility of not only managing, but also dealing with litigations relating to acquisition costs, etc. It is entirely you are, and we are accountable, my lord. We are audited by the Comptroller and Auditor General. So that's the scrutiny that we have to, my lord, face. So therefore, the concept of a beneficiary is technically not attracted to the Nigam like us. We are an assignee of the government. Now, my lord, I'll just take your lordship through the act. My lord, the relevant provisions, my lord. First, if your lordships have a look at Section 3F of the Land Acquisition Act. My lord, as public purpose, my lord. Now, my lord, please see, the expression public purpose includes, subclause 3, the provision of land for planned development of land from public funds in pursuance of any scheme or policy of the government and subsequent disposal thereof in whole or in part by lease, which I assume would include some consideration, assignment, My lord, that's what I'm going to rely upon. Or outright sale with the object of securing further development as planned. So, my lord, this indicates that the government has the leeway of assigning projects which are developed or planned from public funds. That is the exercise of executive power. The state has that power. Now, my lord, this is one aspect. Now, my lord, if your lordship sees, please come to part 7, section 44B. No, sorry, well, before that, your lordship would look at the definition of company. 3CC, company is, my lord, defined under 3E, the same definition clause. 3E expression company means a company, my lord, A1, 3I, a company as, I'm sorry.
Where is it?
My lord, section 3, subclause E, definition clause. Definition of a company.
Ah.
My lord, yes. The expression company means a company as defined under section 3 of the Companies Act 1956, other than a government company referred to in clause CC. So, my lord, company does not include a government company. That is why part 7 does not, my lord, is not applicable to government companies. That your lordship will also find by looking at section 44B. Look, 44B, capital B. My lord, has it? My lord, say 44B reads, notwithstanding anything contained in this act, no land shall be acquired under this part except for the purposes mentioned in clause A of subsection 1 of section 40 for a private company which is not a government company. That is, my lord, section 44, capital B. So it is very clear. My lord, just 44B, 44 capital B. Section 44 capital B, my lord. My lord, it says, notwithstanding anything contained in this act, no land shall be acquired under this part except for the purposes mentioned in clause A of subsection 1 of section 40 for a private company which is not a government company. So, my lord, part 7 does not apply to government companies. That only deals with private companies. And your lordship saw that as far as government companies are concerned, they are treated differently. They are defined differently. Please come back to section 3. Again, subclause C, 3CC.
Yes.
Specifically defines the expression corporation owned or controlled by the state means any body corporated, established by or under a central, provincial or state act, and includes a government company as defined under section 617 of the Companies Act, a society registered under the Societies Registration Act, or under any corresponding law for the time being in force in a state, being a society established or administered by the government, and a cooperative society within the meaning of any law establishing a cooperative society for the time being in force in any state, being a cooperative society in which not less than 51% of the paid up share capital is held by the central government or any state government or governments, or partly by the central government or partly by one or more state governments. So, my lord, that is where, my lord, the distinction is made between part 7 and the rest of this. Now, my lord, I have filed a compilation of judgment, but I'll just take your lordship. Some of them are overlapping with what my learned friend filed, but we had filed much before. Now, my lord, I'll just take your lordship. Lordship, what I've done is that the index, my lord, I've given some headings.
Application was issued when? 1999. 99. Yes. When was this
Two
Nigam
thou-
established?
My lord, 98.
It's established in two.
That also, my lord, I'll deal with that. I'll deal with that. One of the arguments, formidable argument which my learned friend made was, you were not in existence when the Section 4 notification was issued. That has been dealt with by two judgments which is part of this compilation. I'll place that also. So that's the concept of assignment. My lord, the fact that a particular government company was not in existence as on the date of the Section 4 notification is irrelevant. Because, my lord, the point here is who bears the compensation? The government has assigned it to a government entity later on. The litigation would be going on. Can I or can I not be, am I not an interested party in that, the litigation, the ongoing litigation, whether in the stage of an appeal, etc. That's the issue that on that, my lord, there are judgments. So, my lord, first, my lord, my compilation, my lord, what your lordship may just have a look at the index. I have tried to, my lord, put some headings so that your lordship knows for what purpose it is being cited.
Yes.
My lord, the first part is A to H. My lord, I have placed on record the memorandum and articles of association of the Nigam. My lord, that will tell your lordship what is the object of this Nigam being incorporated. And, my lord, and there are certain other government orders which I'll come to later on. Now, as far as the judgments are concerned, but the first proposition is that the Nigam is an interested party, my lord, for which, my lord, Himalayan Tiles, Navely Lignite, and the UP Awas Nigam. So Himalayan Tiles, I will not trouble your lordship because that was a Part 7 acquisition. So therefore, Himalayan Tiles, the company, obviously, if it is acquired for the benefit of a company, it will have to be heard. That's so I'm not relying on Himalayan Tiles. So let's have a look at Navely Lignite and UP Awas. Now, my lord, interestingly, both these judgments were rendered one day apart. Navely Lignite, my lord, is a 3-judge bench decision rendered on 19th October, and on 20th October, the constitutional bench judgment came. So both of them missed each other by one day. So it's interesting, but both of them more or less come to the same conclusion. Now, my lord, please have a look at Navely Lignite. That is at page 130.
Yes.
Now, if your lordship comes to para 1, because in what context did this issue arise? Just, my lord, I will just place para 1 and 2, and then, my lord, I'll just take your lordship. Lord, my lords have the page 132. I am at page 132. These appeals arise from judgments of the Madras High Court in a batch of so-and-so, dated from a judgment of the full bench rendered in Navely Lignite. It was a Rangaswamy. Notification under Section 4.1 of the Land Acquisition Act for short was published in the year 75, acquiring a large extent of 5,200 acres of land for the purpose of excavating inferior quality coal in South Arcot district of Tamil Nadu. Tahsildar, the land acquisition officer, awarded compensation in the year 1977-80 under Section 11. Dissatisfied, the claimant sought and secured over 2,000 references under Section 18 to the Civil Code, namely the subordinate Judge Kadalur, in some of which the Civil Code made awards and decrees under 26. In the pending references, the appellant sought to be impleaded, note this is important, as a party respondent to adduce evidence for fixation of proper compensation. The Civil Code dismissed the application, holding that the appellant is not an interested person by a common order dated 28/11/1986. The High Court, in the revision by judgment dated 16/2/87, upheld the order of the Civil Court. In the appeals filed by the state under Section 54, the appellant sought to be impleaded as a party respondent, which was turned down, holding that the appellant is not an interested person interested. Against that, a batch of appeals have been filed here. The appellants also filed writ petitions challenging the validity of the award and decree made under Section 26 by filing writ petitions. The full bench held that the appellant is not a person interested, therefore dismiss the writ petition. Thus, these appeals have been filed by special leave. When the appeals came up on 3/5/91 before a bench of 2 judges, our learned brethren made a reference to a 3-judge bench thus. We think it would be proper that the entire matter, including the right to seek reference, to adduce evidence, or to claim to be impleaded as a party before the Civil Court, or its right to file appeal before the High Court against the above orders and all other allied questions are necessary to be considered by the 3 judges. Now, my lord, I'll skip the rest of the portions because they deal with the whole catena of case law. Now, your lordship may come to para 12 at page 138. I'm relying on, my lord, para 12, 13 and the subsequent paragraphs. It is true, my lord, page 138. It is true. Yes,
Para
well, para
13.
12, para 12,
Para 12.
para 12
Ah.
at page 138.
Hmm.
It is true that section 50 subclause 2 of the act gives to the local authority or the company right to adduce evidence before the collector, or in the reference under section 18, as it was specifically stated that in any proceedings held before the collector or the court, the local authority or the company may appear and adduce evidence for the purpose of determining the amount of compensation. However, it has no right to seek reference. Based thereupon, the contention is that the limited right of adduction of evidence for the purpose of determining the compensation does not carry with it the right to participate in the proceedings or the right to be heard or to file an appeal under section 54. We cannot limit the operation of section 3B in conjunction with subsection 2 of section 50 of the act within a narrow compass. The right given under subsection 2 of section 50 is in addition to and not in substitution or in derogation of all the incidental, logical and consequential rights flowing from the concept of fair and just procedure consistent with the principles of natural justice. The consistent thread that runs through all the decisions of this court, starting from Himalayan tiles, is that the beneficiary, that is a local authority or company, a cooperative society registered under the relevant state law or a statutory authority, is a person interested to determine just and proper compensation for the acquired land and is an aggrieved person. It flows from it that the beneficiary has the right to be heard by the collector or the court. If the compensation is announced to it is entitled to canvass its correctness by filing an appeal or defending the award of the collector. If it is not made a party, it is entitled to seek leave of the court and file appeal against the enhanced award and decree of the civil court under section 26 or the judgment or of the judgment and decree under section 54, or is entitled to file writ petition under article 226 and assail the legality or correctness. When the award made under section 11 of the collector is vitiated by fraud, collusion or corruption, the beneficiary is entitled to challenge it in the writ petition apart from the settled law that the conduct of the collector or the civil judge is amenable to disciplinary inquiry and appropriate action. These are very valuable and salutary rights. Moreover, in the language of Order 1, Rule 10, in the absence of the beneficiary who ultimately has to bear the higher compensation, no complete and effectual determination of binding just and proper compensation to the acquired land could be made. So it would be concomitantly a proper party, if not necessary party, to the proceedings under Order 1, Rule 10. The denial of the right to a person interested is in negation of the fair and just procedure offending Article 14 of the Constitution. The reasons, my lord, this is also important. The reasons are not far to seek, though I'm not, my lord, trying to say that this is the case here. It is notorious that the stakes involved are heavy. The government plead or the instructing officer do not generally adduce, much less proper and relevant evidence to rebut the claim for higher compensation. Even the cross-examination will be formal, halting and ineffective. Generally, if not invariably, the governmental agencies involved in the process take their own time and many a time in collusion, file the appeals after abnormal and inordinate delay. They remain insensitive even if the stakes involved runs into several crores of public money. The court insists upon proper explanation for every day's delay. In this attitudinal situation, it would be difficult to meet strict standards to fill the unbridgeable gaps of the delay in filing the appeals, and generally entails dismissal of the appeals at the threshold without adverting to the merits of the hike in the compensation. On the other hand, if the notice is issued to the local authority, etc., they would participate in the award proceedings under section 11 and 18, adduce necessary and relevant evidence, and be heard before the collector and the court before determining compensation. For instance, that without considering the evidence or is in the proper perspective, the court determine the compensation. If there is no right of hearing or appeal given to the beneficiary and the state does not file the appeal, or if filed with delay and it was dismissed, it is not the beneficiary who undoubtedly bears the burden of compensation. Who would be the affected person? Is it not interested to see that the appellate court would reassess the evidence and fix the proper and just compensation as per law? For instance, the reference court determined market value of 1 lakh while the prevailing market value of the land is only 10,000 rupees. Who will bear the burden? Suppose a state appeal was dismissed due to refusal to condone delay. Is it not just an illegal award? Many an instance can be multiplied, but suffice it to state that the beneficiary for whose benefit the land is acquired is served with the notice and brought on record at the stage of inquiry by the collector and reference court under section 18 or in an appeal under section 54. They would be interested to defend the award under section 11 or 26 or would file an appeal independently under 54, etc., against the enhanced compensation. As a necessary or proper party affected by the determination of the higher compensation, beneficiary must have a right to challenge the correctness of the award made by the reference court under 18 or an appeal under 54. Considered from this perspective, we are of the considered view that the appellant company is an interested party within the meaning of 3B of the Act and is also a proper party, if not a necessary party under Order 1, Rule 10. The High Court has committed manifest error in law in holding that the appellant is not an interested person. The orders of the High Court are accordingly set aside. Then, my lord, my learned friend pointed out to this paragraph that the writ petitions were ordered to be treated as an appeal under 54. My lord, that is an exercise of power under 142. So, my lord, so therefore, your lordship saw, number one, your lordship saw that the court says that a writ is maintainable. Permission to file an appeal under 54 is also an option available to you. So either of the options are available to a party who is an interested party. Who is the interested party? The party who actually pays the compensation. Whereas, my lord, I will show from the KIDB, the Pira Pass judgment, that was a case where the beneficiary does not pay compensation. He pays additional costs for the land allotted to him by the allotting agency. So there is a conceptual difference between the two. So here, your lordship sees the long and short is, the government acquires the land for a particular irrigation project. That project is assigned to me lock, stock and barrel with all the attendant assets and liabilities. That is distinct from being a beneficiary. In the larger sense, I am not really a beneficiary. I am somebody who has been assigned by the state, my lord, in exercise of its overwhelming power, executive power, my lord, and the legislative power that it has. For example, you have the Karnataka Irrigation Act. It also, my lord, there are consequential amendments to the Irrigation Act also, by which nigams have been given the power to collect cess, etc. So this is the act of the state, the state's power of in the economic activity. It can devise these kind of agencies for the purpose of raising funding for public projects. So there, my lord, to say that I will not make you a party, I will file appeals without making you a party, I will get enhanced compensation, but I will come and execute that decree against you. That can't be. If it was a case of the appellants that yes, I will execute the decree against the state, that's a different case altogether. That's understandable. So you execute, you make the state a party, go and execute it against the state. Yes, you are entitled to. Nobody can prevent you from I am nobody to come and say anything on that. But when I am given the repository of economic financial powers, I am answerable to the state and to the Comptroller and Auditor General. I have to defend the interests of the public. So therefore, my lord, this, now, my lord, likewise, my lord, your lordship sees Avas Nigam.
Ultimately, everything boils down to this.
Yes.
That you are stating that you are paying out of your pocket.
Correct.
Now, your own documents, which the learned counsel was pointing out.
Yes.
Clearly shows that you are asking for that money from the government itself.
Yes.
It is not coming from your.
No, I'll tell you, lordship. Yes, but I must explain that. But what happened?
If that is the contention.
Yes.
Then I don't think you will have a merit in your argument.
No, Malay.
Just clarify that aspect.
Yes, I'll tell you, lordship. Now, what happens is.
Now, if your communication shows.
Yes.
That you are calling on the government that this is the award passed, this is the enhanced amount. So kindly ensure that it is paid. If the government is paying it.
Well, I'll tell you, lordship. I'll explain that.
On facts, you'll have
Malord,
to.
On the facts, Malord, let me explain. Malord, I
yes.
indicated to the predecessor bench this aspect. Now, what we do is, obviously, Malord, the entire money that is required for paying compensation or for running the projects, we are not able to get it through raising from the market. So what happens is, we approach the government. The government gives us grants. Those grants are converted into, Malord, equity. So, the equity of the company keeps growing because of the grants given by the government. It is not by way of, a direct allocation of funds. It is not that we are borrowing, we are taking money from the government, and we are merely a channelizing agency. Every time we require funds for the purpose of the projects, we take grants from the government, which is then treated, converted into equity in the company. So that is, the money is therefore appropriated by the company. So that is an arrangement which is very much, that is very much permissible under law. And that is what is happening. So, my lord, the equity of the company over the years keeps growing. And therefore, my lord, what happens is the company's value, the invested value in the company keeps growing because of these grants. So what happens is that if the special land acquisition officer says that, why don't you have to disperse this amount? That is not binding on me, because the special land acquisition officer is a representative of the state. His job is as a representative of the state exercising power of eminent domain. He sits in my office. One of the arguments laid by him, my learned friend, was that, look, your special land acquisition officer is sitting in your own office. That is only for the purposes of efficiency, because we go and tell the government, the special land acquisition officer, that we need to acquire 20 acres of land at this particular site for this purpose. So he initiates that process as the government, because I, as the Nigam, I don't have a special land acquisition officer. The government allocates him to us so that our job is facilitated. So when the special land acquisition officer says, look, under this reference, this amount has to be disbursed. So I may choose to, my lord, go and challenge it in appeal. That's my independent power that I have. I am not bound by the advice of the special land acquisition officer, because his role is only limited to acquiring the land and dispersal of the funds which is made available to him, because under the act, it can be dispersed only through him. So these documents that my learned friend is which we have filed, it only shows that, yes, the amounts are given to us by the government as by way of grants. All the other documents I'll show. That does not mean that I am merely a channelizing agency for dispersal of compensation. I'm not a post box. I am not merely an agency of the government. I have full powers of challenging matters in appeal. I have a right to defend. Lord, it is my sole responsibility and obligation for which I have been established to do so. So I have to do that job. So, my lord, I'll of course take your lordship through those documents again. Now, my lord, coming back to the judgment, my lord, Avas Nigam is, my lord, one day after this navally lignite, that is at page 142. I will not trouble your lordship, because this has been extracted in detail. My lord, the relevant para 24 at page 160 has been, my lord, referred to by the learned single judge. And the summary, my lord, para 5, to show that the writ petition is maintainable. My lord, page 160, para 24. Your lordship just notes clause 5, para 24. Even when a notice has been served to the local authority, just because the para 4, sorry, clause 4. In the event of denial of the right conferred under section 52 on account of failure of the collector to serve notice of acquisition proceeding, the local authority can invoke the jurisdiction of the High Court under Article 226 of the Constitution. 5. Even when notice has been served on the local authority, the remedy under Article 226 of the Constitution would be available to the local authority on the grounds on which judicial review is permissible under 226. 6. The local authority is a proper party in the proceeding before the reference court and is entitled to be impleaded as a party in those proceedings wherein it can defend the determination of the amount of compensation by the collector and oppose enhancement of the said amount and also adduce evidence in that regard. 7. In the event of enhancement of amount of compensation by the reference court, if the government does not file an appeal, the local authority can file an appeal against the award in the High Court after obtaining leave of the court. So, my lord, all these powers, my lord, this is only by way of explanation as to why whoever is liable to pay the compensation has a right to be heard. So that's the principle. Yes.
We are asking you, now that you have placed certain material before this court, and it is being pointed out by the learned counsel for the
yes
appellant.
Yes.
That your own documents show that you are not actually paying the amount. It is again coming from the government itself.
Well, that
therefore,
yes,
when the government has represented and it has contested the matter,
yes,
both before the first appellate court and the reference court and the first appellate court,
no,
how can you now say
yes,
no, our interest will be harmed because we are paying it. We are in fact paying it.
Yes.
See, and it is also being pointed out.
Yes.
That in paragraph number 24.
Yes.
The conclusion that is drawn in UP Awas Nigam.
Yes.
Directions number 1 to 5.
Yes,
no doubt say that yes,
Yes.
writ petition is maintainable,
yes,
but under what circumstances? In 7, it is
Yes.
clearly stated that if you are contending regarding enhancement of the
Yes.
compensation,
yes.
then you can only file an appeal.
No, no, no.
That is,
No,
read
no,
it
no,
out
no,
just
I
now.
saw that, I saw that, no.
So let
Yes.
us read from directions number 1 to 5.
Yes,
If these are not pertaining to stages where you are seeking to challenge the enhanced compensation,
yes.
then you only have to file an appeal in terms of direction number 7.
No, but navally lignite your,
See, what is it that has
Yes.
been said
yes,
from 1 to 5?
yes. Yes, 1 to 5, my lord, says that where, my lord, 1 to 5 deals with situation where the local authority is not made a party.
Correct.
Now, 7 says in the event of enhancement of compensation by the reference court, if the government does not file an appeal, the local authority can file an appeal against the award in the High Court after obtaining leave of the court. This is one of the options available to me because that is, my lord, they will lignite.
Therefore, let us see
Yes.
what are the circumstances under which a writ petition can be filed.
My lord, that
Contention is,
yes, yes,
these are not situations where
yes,
the beneficiary like you
Yes.
is trying to challenge the enhanced
correct,
award.
correct.
These are the other situations where
I am in appeal.
matter arises before the reference.
Yes, correct.
If that is not the situation, then again, you will not be permitted to file writ
My lord,
petition.
what you-
Now let us see
Yes.
what are the directions from serial number 1 to 5.
1 to 5. Let me read
Yes.
that. Yes. Section 52 of the Land Acquisition Act confers on a local authority for whom land is being acquired a right to appear in the acquisition proceedings before the collector and a reference court and adduce evidence for the purpose of determining the amount of compensation. So, my lord, I take it your lordship is right. This is at the stage of acquisition.
Correct.
So this is, we are all dealing still at the stage of acquisition. 2, the said right carries with it the right to give adequate notice by the collector as well as a reference court before whom acquisition proceedings are pending on the date on which the matter of determination of compensation will be taken up. Again, dealing with the acquisition stage.
Correct.
So this is not our case. 3, the proviso to section 52 only precludes a local authority from seeking a reference, but it does not deprive the local authority which feels aggrieved by the determination of the amount of compensation by the collector or the reference court to invoke the remedy under Article 226 of the Constitution as well as the remedies available under the Act. So, my lord, this is a different proposition. Now, this
Proviso to section 52.
yes. The proviso to section 52 only precludes the local authority from seeking a reference, but it does not deprive the local authority which feels aggrieved by the determination of amount of compensation by the collector or by the reference court to invoke the remedy under Article 226 of the Constitution, as well as the remedies under the Land Acquisition, which means, which would, in my respectful submission, would include appeals under 54 as well. So 3 deals with the situation post acquisition.
Let us read the section 50.
Yes, let's have a look at section 50. May I read?
Yes.
Where the provisions of this act are put in force for the purpose of acquiring land at the cost of any fund controlled or managed by a local authority or of any company, the charges of an incidental to such acquisition shall be defrayed from or by such fund of company. 2, in any proceeding held before a collector or court, in such cases, the local authority or company concerned may appear and adduce evidence for the purpose of determination of the amount of compensation, provided that no such local authority or company shall be entitled to demand a reference under section 18. So, my lord, this deals with local authority. My lord, let's assume that I'm a local authority. So, subclause 2 allows the local authority to adduce evidence for the purpose of determining compensation And subclause 1, your lordship saw the test again is who pays the compensation.
Unfortunately,
Yes,
in the present case, at the time of issuance of 401 notification,
yes,
you were not in existence.
that's right.
I do not know.
My lord, we came into effect in 1998. We were 98. Here-
98.
Yes, yes.
You were established
Yes,
in
yes.
98.
Yeah, what is the date of notice?
Then,
Ah.
if you were established in 98
Yes,
and the acquisition was not expressly for your purpose,
yes.
then how will you fit into the definition of?
Because the
beneficiary?
government in exercise of its powers of assignment has assigned it to me. The government has,
Government may do anything. We are only required to consider your
Yes.
submissions
yes,
having regard to the provisions of the act.
correct, 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 correct.
So, in the act itself, definition of beneficiary is given.
Yes. No, beneficiary is not given. That's the problem.
Huh?
Beneficiary is not defined under the act. Person interested is defined.
Person interest.
Person
has been-
interested is defined.
Person interest has been defined.
Yes, yes,
And specific provisions are made,
yes,
which would apply in, for instance,
Right.
section 50,
yes.
which has also been referred to in the judgments of the Supreme
Correct,
Court.
correct.
Where it is clear that the acquisition is for the benefit of the local authority or a company. You
Yes.
may be a company. You
Correct.
do not know. Probably you are a company established under the
No,
company.
this is this refers to part 7 company. That's a private company.
Huh?
Well, part 7, section 50 is part of part 7.
Hmm.
It is in part 7. So when they refer to a company, they mean a private company, not a government company.
Hmm.
That's, my lord, part 7, if your lordship sees.
Hmm.
No, I'm sorry, this is a part of the part 8. This section 50 is
Therefore-
part 8. Yes. So let's assume that,
Yes.
because we'll have to go by the definition.
May apply because the local authority is used here. The word local authority is used here.
Yes. My lord, my lord, company would be as defined under the act, even for section 50. It will be a
Yes.
private company,
Ah,
not a government company.
ah.
Because the expression, my lord, your lordship saw the definition clause, it excludes a government company. So section 50, when it refers to a company, it excludes me. I'm not, I would be generally covered under the expression of,
Then it will become that much more difficult for you.
my lord, I'm telling your lordship,
Having regard to the express provisions in the act.
right, right,
Where it takes care of a situation where the land is acquired for the benefit of a local authority
correct.
or a company, be it a private company or a government company.
Right.
Everything ultimately boils down to this question, that if you are paying the amount of compensation
Yes.
determined,
Yes,
you are entitled to raise all objections.
absolutely.
That is the basis.
That's the base. That's
Isn't
the,
it?
that's,
Now, therefore, having regard to this provision, if you have been established in the year 1998 itself, and in the 401 notification or in the 61 notification, you have not been shown as the beneficiary, then what is the position?
my lord, so I'll just directly answer that. My lord, I'll take your lordship through those 2 judgments which I was referring to. Now, my lord, this part of this couple. Let's have a look at those judgments. One is a Supreme Court judgment, the other is a division bench of the Bombay High Court. No, we'll just show that first, straight away.
Interesting.
Please see section 19.
19,
My brother is pointing out to section 19.
section 19. Collector's statement to the court. In making the reference, my lord, sir.
Correct.
In making the reference, the collector shall state for the information of the court in writing under his hand, A, the situation and extent of the land with particulars of any trees, buildings or standing crops thereon. B, the names of the person whom he has reasons to think interested in such land.
This is important.
This is important, yes.
Yes.
The amount awarded for
So-
damages, yes,
Even in this
yes,
statement,
yes,
if the deputy commissioner or the special land acquisition officer does
Yes.
not state clearly that you are an interested person,
yes.
then what is the position?
So, my lord, there are two situations. One is, my lord, as your lordship rightly pointed out, if as on the
It
date
was
of,
clear that you are bearing the costs,
yes,
then invariably the special land acquisition officer would have stated, yes, now the project has been handed over to KNNL and therefore they are persons.
yes,
They are the persons who are going to pay the compensation
yes,
and therefore you would have given all the rights
yes,
to raise objections.
yes. No, my lord, my lord, I understand, but your lordship, sir, there are two situations. One is, as your lordships pointed out, what if on the date of the notification under section 4, you were in existence, but you were not involved in the process?
Correct.
Second is, you were not in existence, you came into being much later on, then what is your position?
Correct.
The answer to both the situations is the same. The test is who pays the compensation. That seems to be the underlying spirit, whether you look at section 20 or 50 or any of the provisions. Now, your lordship wanted me to read 19.
Only
Now,
drawback in their case is,
yes,
as you pointed out, that they are trying to execute these awards against you.
yes.
That is the only drawback in their case.
Lord, that
No,
also.
my lord, apart from that,
Otherwise-
my lord, I'll take your lordship, my lord, because, my lord, we want your lordship's assistance because this needs to be settled. Because, my lord, we have this problem, it's not a one-off case.
No, if we
There are-
are holding that you
Yes.
cannot be treated as an interested person, you cannot be treated as a beneficiary, we will also direct that these awards cannot be executed against you. We will make it clear.
My lord, the learned AG is also going to appear in this matter. My lord, he'll probably be appearing on the next date. My lord, I want your lordship, while at section 19, please have a look at section 3, subclause B, which talks about.
You will have to answer that.
Yes.
Lord, I will.
You are
give a-
raising so much of objections.
Yes.
Then how is it that as a matter of right, you are going and trying to execute these awards against the
Not,
KNNL?
not one case, not one execution filed, my lord, against these parties. Executions are filed against only the, my lord, SLO. I will give an undertaking saying that I will proceed only against the person judgment debtor in the, Lord, LAC. My lord, it is, my lord, that an illusion is created. They are showing as if, my lord, we are.
Not by officers are being on the threat of.
May not be by your parties. May not be by your
How?
parties.
How?
But as a matter of right, if many other claimants
Many,
have
yes.
filed execution cases trying to recover the amount from KNNL, then there is something.
Yes, my lord. For that, my lord, I have a simple solution. They must question the order of, my lord, that execution court saying that we are not the judgment debtors. Execution cannot be against us. That's all. If they challenge that in a writ, it has to be quashed. They don't want to do that. They want to set aside the original award itself, my lord. That's the difficulty. My lord, since, my lord, with kindly,
Yes.
his leave, my lord.
Yes.
Since we were on, my lord, section 50. Lord, section 50, my lord, is the enabling provision which provides or requires, my lord, them to file, my lord, give them notice and, my lord, other things.
Yes.
Section 50, if you read the first line, my lord, it clearly states, my lord, where the provisions of this act are put in force for the purpose of acquiring land at the cost of any fund or service.
Then
So,
everything ultimately
4-1
boils down to this.
4-1 ನಲ್ಲಿ ಅವ್ರು ಇರ್ಬೇಕು. It should-
Adalla, that
it
is
should
not
be.
important. What is important is that they are paying the costs. They are paying the award. They are paying the compensation. Ultimately, if everything is coming from them, then they should be treated as interested parties. This is what the observations of the Supreme Court also.
Yes.
Ultimately, everything boils down to this.
Yes.
If it is clear that they are paying the costs, they are paying the award, they are paying the compensation, then they will definitely have a right to raise objections.
Look, we, my lord, say that we are not executing
That
against
is
them.
why the
There's no
Supreme
question.
Court also has made so many observations. We can't ignore the truth of the fact that the government agencies, the SLAOs, the collectors, deputy commissioners, whoever are representing the interest of the state are not doing it very well. But if that converts into a burden on the beneficiary or the person who is actually paying it, then you have to treat him as an interested party. This is how we'll have to look at it. Not merely by saying when it was established, whether it was assigned or whether it is an allottee, this becomes irrelevant. The words that are used, that allottee, assignment, these are not relevant. Ultimately, what is relevant is that whether they are bearing the brunt.
Yes, my lord, I followed, my lord. Your lordship is concerned about the fact that, my lord, somebody else is contesting and, my lord, somebody
Correct.
else has to, my lord, bear the award. Look at the other way of, my lord, the situation. My lord, I contest, my lord, genuinely. Now I implead them and contest against them. Tomorrow, my lord, it is transferred to somebody, some other person. This has happened. Karnataka Niravari Nigam was, my lord, transferred to Kaveri Niravari Nigam, interstate transfers. All that are there. So where do I go? What agreement the government does with its agency or creates an agency, special purpose of it. Lord, these are all not the concern of the, my lord, the claimant. What will happen is, my lord, we will be put to, my lord, serious prejudice. You allottees transfer madkoto hodre, avaru papa, they are supposed to pay, so make them party. I make them, they transfer it to somebody else. By the time they have the award, my lord, somebody else is the owner. So he will file an appeal saying that I was not a party as on the date of award. I should have been a party. I am the owner. Where is the, my lord? And my lord, in fact, my lord, there is my lord, some salutary, my lord, sense in the my lord, the provisions which are made. Section 20, it says once it is for government. If he says I'm government agency, I'm government vehicle, I'm this, that, it is only the deputy commissioner. Yakantandre, the legislators, my lord, they assume that, my lord, if you make somebody as a party, he may come and say, no, it was not under this department. Some other department was there. Not this subdivision, some other subdivision. So there will be no end to that.
But in fact, there are many checks and balances in the provisions itself. Now, for example, the section 19, whatever my learned brother has pointed out.
Yes.
It is the duty of the SLAO to give this information that yes, the project has been assigned to KNNL. They are interested parties. So therefore issue notice to them. Once that is done, everything will come to a proper stage where the matter can be considered on merits.
Yes. It is
and
good.
They will not have they will not have a say. No, I was not informed.
I will clarify that also. SLO now, my lord, after the projects are handed over to them, very same project, he is making a mention, my lord, that in the 19th statement. UL cases, before there, my lord, though they were established in 98 December, project was given to them in 2005. Before 2005, they had no business with the project. It was completely government project. So 2005 kina munche iradu, avku enaiti the 19th statement, there is no occasion for the SLO to state their name. All acquisitions subsequent to 2005, their names are stated. They are made as party. We have taken orders against them also.
My lord, the law cannot be decided on a default. My lord, that's not the basis to test it. My learned friend himself has made us parties at a time when the project was not even assigned to us. My lord, there are so many matters, they have selectively made us parties. In many matters, not made parties. And these are all matters where there are unconscionable delays of 5,000 days, 10,000 days, my lord, 20 years delay. My lord, so many matters, not all these matters are those kind of matters. My lord, I can understand, my lord, if by due diligence we did not take steps, then we are accountable. But if we have no clue about the matter, we get to know when there is a warrant of attachment or an order of execution. The SLAO is forwarding the execution warrant to us, and our officers under threat of arrest, our assets are being attached. My lord, this is a problem that we are facing. It's not a simple case of, my lord, somebody being choosing to make us a party or not. The law has to be settled elaborately, my lord. We will have this problem otherwise. Now, my lord, while we are on the person interested, please have a look at that definition at section 3, subclause B. My lord, which defines person interested. 3B, my lords have it? Yes.
Ah.
The expression person interested includes all persons claiming an interest in compensation to be made on account of the acquisition of land under this act, and a person shall be deemed to be interested in land if he is interested in an easement affecting the land. So, my lord, this is a very wide definition. It is not merely restricted to somebody who is a person interested as on the date of the initiation of the acquisition process, but anybody who gets interested, even that's a matter to be interpreted by your lordship. I'm saying so. Lord, it can include a person who acquires an interest subsequently by way of an assignment, but not somebody who is an allottee or a lessee. That would be a different concept, which, my lord, we have already seen. Now, my lord, interestingly, what I must tell your lordship, my lord, just while we are at this, there is a judgment of this court in 2014, where a learned single judge says, in all these matters, the government cannot prosecute appeals. It is only the Nigam which will defend or prosecute the appeals. And following that judgment, the government issued a notification in July 2014 that is on record. I'll take your lordship through that. So 2014, this court has held that the government is not a party to these proceedings. It cannot file appeals. It cannot contest. It is a responsibility of the Nigam. And the government, in compliance with that mandamus, issued a GO. In spite of that, my lord, somehow government lawyers appear, they accept notice, but Nigam is not made a party. That's the problem that we are facing in spite of it. And repeatedly, my lord, even now the government has been issuing those kind of notifications. This very year, the government has issued those notifications. Now, my lord, on that question that your lordship very pertinently asked me, what is the position in law if you are not in existence as on the date of the Section 4 notification? There are two judgments, my lord. One is a Supreme Court judgment and another one is a very elaborate Bombay High Court division bench. My lord, your lordship will find the Supreme Court judgment at page 183. This is, my lord, Abdul Razak versus Kerala Water Authority. And your lordship may also bear in mind who was that beneficiary or the entity in whose favor, my lord, this project was. They are all government bodies, my lord. They are all dealing with government activities. Lord, just Lord, please come to page 185. It's a short judgment, so I'll just quickly go through the relevant portion. My lords have page 185.
Yes.
Under a notification dated 19 July 1981, issued under Section 4 of the Land Acquisition Act, the state of Kerala acquired land for the benefit of the Public Health Engineering Department of the state government. On 27/8/82, possession was taken over the acquired land. Sometime in June 1983, a declaration under Section 6 of the Land Acquisition was made. The collector initiated proceedings for assessing the amount of compensation payable and made an award on 15/6/1986. The claimant sought for a reference to the civil court seeking enhancement in quantum of compensation, which was made. These reference applications came to be decided by different awards made by the civil court between 1989 and 1991. With effect from 1/4/1984, the state of Kerala, through an executive order, constituted the Kerala Water Authority as a statutory corporation. The Kerala Water Supply and Sewerage Board, Sewerage Act 1986, which was given retrospective operation with effect from the 1st of May 1984, declared the Kerala Water Authority to have been constituted under the Act. The state of Kerala and the Kerala Water Authority preferred appeals, laying challenge to several awards made by the civil court and for enhancement of compensation. During the pendency of the appeals before the High Court came the constitutional decision of this court in UP Awas Nigam, wherein it was held that the company for whose benefit the land was acquired was also entitled to appear and adduce evidence for the purpose of determining compensation. One of the grounds which persuaded the Constitutional Bench in forming that the opinion was that the amount shall have to be paid by the local authority, and therefore it was a proper party entitled to contest the proceedings. We need not reproduce in extenso the law laid down by the Constitution Bench. For our purpose, it would suffice to note that in the opinion of the Constitution Bench, the right conferred on the local authority under Section 52 of the Acquisition Act, in the light of the scheme of the Act, carried with it the right to be given adequate notice by the collector as well as the reference code before whom the acquisition proceedings are pending on the date on which the matter for determination of compensation will be taken up. The local authority is a proper party in the proceedings before the reference code and is entitled to be impleaded as a party in those proceedings wherein it can defend the determination of the amount of compensation by the collector and oppose the enhancement of the said amount and also adduce evidence in that regard. In the event of enhancement of the amount of compensation by the reference court, if the government does not file an appeal, the local authority can file an appeal against the award in the High Court after obtaining the leave of the court. The Constitution Bench, however, it added a rider to its judgment that the law laid down will not have the effect of reopening the matters which finally stand concluded. It cannot be doubted that on 20/10/94, the date on which the Constitution Bench delivered its judgment, the matters relating to the compensation in the present case had not achieved finality and had not stood finally concluded, inasmuch as the same was pending in appeal in the High Court, and an appeal is a continuation of the original proceeding. So far as the award given by the collector is concerned, that can be said to have become final before the date of the decision of the Constitution Bench, but not the award given by the civil court on reference. The High Court, in its impugned judgment, formed an opinion that the law laid down by the Constitution Bench governed the case at hand, and therefore the award given by the civil court on reference stood vitiated for want of notice to KWA. The High Court allowed all the appeals pending before it and remanded the case for decision afresh by the reference court after affording the parties an opportunity of adducing evidence in support of their respective contentions. Feeling aggrieved by the order of remand, the claimants have filed these appeals by special leave. Lord, I'll skip the submissions. Your Lordship may just come to para 8. My learned friend want me to read the submissions also. It may be. TLV Iyer, the learned senior counsel for the claimants, submitted that the Kerala Water Authority is a successor of the Public Health Engineering Department of the state government and is bound by the proceedings conducted by or against the state government, and therefore this Constitution Bench decision does not have any applicability to the facts of the present case, and the High Court ought not to have set aside the awards and remanded the case to the reference court. We find it difficult to subscribe to the view as so forcefully canvassed by the learned senior counsel for the appellants. KWA came into existence as a statutory corporation on 1/4/1984. It may be said to have succeeded to the liability incurred by the state government so far as the quantum of compensation awarded by the collector is concerned. But so far as the enhancement in the compensation of quantum of compensation is concerned, it will be the liability of KWA incurred by it after its coming into existence, and therefore, to the extent of enhancement, the authority was certainly entitled to notice and right to participate in the proceedings before the reference court leading to the enhancement of compensation. Learned counsel for the claimant appellants also submitted that the superintendent engineer of KWA, who appeared as a witness in the proceeding before the civil court, and therefore it can be inferred that the authority was aware of the proceedings, and if it did not promptly take steps for impleadment, it should not be heard to complain before the High Court that it did not have notice of the proceedings and that it was denied the participation in the proceedings before the civil court. It has been held by this court in Agra Development Authority that where land is acquired at the cost of a local development authority, a notice to it was mandatory, and simply because the local authority was aware of the proceedings and had participated in the meetings where the matters as to compensation were discussed, was not sufficient compliance with Section 50 of the Land Acquisition Act. In our opinion, the High Court has not erred in taking the view which it has taken and directing the reference court to be remitted to the civil court consistently with the law laid down by the Constitution Bench, as KWA shall have to be impleaded as a party to the proceedings before the civil court from the very beginning. A retrial becomes unavoidable. However, the learned counsel for the appellant submitted that certain directions are called for, inasmuch as some of the witnesses examined by the claimant may not, well, that, Lord, we can skip. And therefore, Lord, para 11, keeping in view the fact that the Constitution Bench judgment of this court was delivered during the pendency of appeals before the High Court, and the manner in which KWA came to be constituted after the commencement of the land acquisition proceedings, and the delay which has already taken place in the conclusion of the proceedings for finalizing compensation, which delay is not attributable to the claimant, though we maintain the order of remand made by the High Court, but make the following directions. KWA shall be deemed to have been brought on record in the reference cases as defendant. The cause title of the reference case shall be amended accordingly. KWA may by, those are the operative directions. So, my lord, dear lordship, this is one such case where as on the date of acquisition, the company was not in existence. It came to be constituted subsequently, and this is the law laid down. Now, my lord, the next judgment is at page 189. This is a division bench of the Bombay High Court. I am referring to this, my lord, because the beneficiary, the so-called beneficiary here also, in this case was also an irrigation, my lord, a company incorporated for the purpose of management of irrigation projects. Yes, yes, good. Plus, please see the first para itself. at page 191. My lord, this is the judgment starts at 189. It's a Bombay High Court division bench.
Where in your index, Abdul Razak?
Yes.
Yes.
Yes. Lord, Lord, please come to para 5. नहीं, उसमें ही आ गया.
Yes.
Writ petitions filed by the corporation were primarily dismissed by the learned single judge on a very short ground. It will be useful to refer to the relevant part of the impugned judgment. Reads as follows. The possession of the land was taken by the government on 10/12/1985, and an award has been declared by the SLAO on 30/10/1987. Thereafter, reference was made by some of the affected persons under Section 18, and the same was decided by the Civil Court by passing an order and judgment on 7/4/1995. Admittedly, the petitioner has come into existence only on 1st October 1998, as mentioned in para 1 of the petition. Thus, the petitioner was not in existence till the entire acquisition proceedings were completed and till the enhanced compensation is awarded by the Civil Court under the provisions of Section 18 of the Land Acquisition Act. In that view of the matter, the contention of the learned counsel for the petitioner was that for the purpose of giving a similar benefit to other parties who are also affected by the same award under the provisions of Section 28A, petitioner ought to have been heard and has no merits. Petitioner is not concerned with the acquisition proceedings which had been completed prior to the incorporation of the petitioner, and therefore the contentions raised by the petitioner are without merits. In that view of the matter, there is no substance to the present petition. The petition is accordingly dismissed. In view of the dismissal, civil application does not run. As evident from the above recorded findings, it is clear that the genesis of the impugned order is that the corporation came into existence subsequent to the passing of the judgment dated 7th April 1995. It has no locus or right to be heard by the SLAO before whom the petitions were filed under Section 28A of the Act. The original award was made by the SLAO on 30th November 1987, awarding compensation of 6,500 to 12,500 per hectare for the acquisition of lands of the claimants depending upon the nature and potential. As already referred, this compensation was enhanced by the reference court by its judgment dated so-and-so to 24,000 to 40,000 per acre. The present respondent number 2, that is a claimant, filed their petitions under Section 28 of the Act between so-and-so, that is after the pronouncement of the award by the Joint District Judge Nasik. SLAO granted relief to the claimants, landowners, and awarded compensation payable at the rate of so-and-so per hectare depending upon the nature of the potential of the land. Learned single judge has not touched on the merits of the case, but has only proceeded on the basis that the corporation was neither a necessary nor a proper party for the reason that they came into existence subsequent to the order passed by the Joint District Judge Nasik on 7th of April 1995. Thus, we have to examine whether the corporation would be a necessary or a proper party to such proceedings. The Supreme Court in the case of Neyveli Lignite explained the term person interested after some discussion and reference to law. The court held that the local authority or the company for whose benefit the land is acquired is proper, if not a necessary party, within the meaning of Order 1, Rule 10, and thus they have a right to participate in the reference proceedings under Section 18 of the Act. The court held as follows. Lord, I am just skipping that part. Then para 8, Constitution Bench in Awas Nigam discussed this principle in great elaboration and noticed that the local authority or a company has a right to participate in the proceedings for determination of compensation, though they are not a necessary party, but being a proper party, it must be implemented in the proceedings before the reference court so as to enable it to oppose the claim for enhancement of compensation. The court further clarified that any such authority or company has a right to invoke remedies available under 226 of the Constitution of India as well as under the Land Acquisition Act. That is a wide scope given to the rights of the authority or the company for whose benefit the land is acquired. And then, my lord, lordship may come to para 11, my lord. I'll just skip the my lord, the court, after referring to the other judgments referred to in para 10 and 11, para 11. From the above settled principle of law, it is clear that the corporation or a company for whose benefit and public purpose the land is acquired by the state would be a proper party entitled to participate in the proceedings at all relevant stages. Determination of compensation is not only confined to the proceedings before the collector and the reference court, but it extends to proceedings before the appellate court or any other forum in accordance with the provisions of the Land Acquisition Act, provided the issue relates to determination and announcement of compensation. Section 3B of the Act explains and defines the word person interested. The said expression is stated to be inclusive of all persons claiming an interest and compensation to be made on account of acquisition of lands under this Act, and the person shall be deemed to be interested in the land if he is interested even in an easement affecting the land. Section 9 of the Act also refers, shall require all person interested in the land to personally appear personally or by agent before the collector. Section 11 also refers to this expression. In somewhat distinction to the expression used earlier, Section 18 refers to any person interested, thus indicating the wide and liberal meaning of that expression, that the expression is intended to be given by the legislature in different provisions of the Land Acquisition Act. Then 12, the body, corporation or company for whose benefit the land has been acquired being a proper party would be entitled to the notice and implement in the proceedings before the authorities and reference court and even the appellate court, the appeal being a continuation of the original proceedings. Merely because the corporation is a successor or is created legally or technically on a date subsequent to the pronouncement of the award itself, by itself, cannot be a ground for holding that the said corporation or company would not be entitled to similar right and obligations as are contemplated in acquisition laws. The proceedings before the SLA under Section 28A of the Act are fresh proceedings for awarding of compensation, and the collector is under an obligation to give notice to all interested persons in terms of Section 28A2 of the Act. In the present case, right from the beginning, the land has been acquired for a public purpose, namely Kadava project, and in continuation of the same public purpose, a corporation has been established by the state, being Godavari Marathwada Irrigation Development Corporation, by a legislative act issued by the competent legislature. Merely because this corporation was established in the year 1998 and the award of the joint district judge was passed on 7th April 95 per se, cannot be a ground for rejecting the claim of the corporation or being heard before the SLAO in the proceedings under 28A or in the appeals if preferred against the judgment of the reference court. While considering the case for announcement of compensation under 28A, the SLO is expected to appreciate the evidence and as to examine the lands. I'll skip that. Then Lord Abdul Razak is referred to in para 14. Then Lord, please see para 16. I'll just read para 15 also. The learned single judge appears to have proceeded on the basis that the pronouncement of an award dated 7th April 95 has to be an end to the proceedings. Firstly, it is not clear from the record whether appeals against the order of judgment dated 7th April has been forwarded by either parties to the proceedings or not. In any case, the proceedings under 28 of the Act are proceedings for redetermination of compensation. Once the collector makes an award under so-and-so, accepting, rejecting, or partially accepting the above claim, the recourse open to the claimant would again be by filing an application under 28A3 of the Act, which would be governed by Section 18 to 28 of the Act. In other words, the entire process that have to be followed after passing the award under 28 of the Act will be identical in facts and law to the remedies available to the claimants against an original award made under Section 11. Then, Lord 16, this is where the assignment principle comes in. This can also be examined from another point of view. Under Order 22, Rule 10 of the CPC, a party is entitled to assign its rights in a legal proceeding to a third party during pendency of the original proceedings or even after passing of a decree in the appellate proceedings. Of course, this has to be done with the leave of the court. Once the leave of the court is granted, the proceedings can be continued by an assignee. The stage of the proceedings is irrelevant, so insofar as the other requirements of these provisions are satisfied and the leave of the court is obtained. The corporation has come into existence by virtue of a legislative act and not a contractual act. The corporation would be entitled to be implemented into the proceedings from the date of its existence and would be entitled to participate in the proceedings which are instituted thereafter or at the stage where they were pending. In the present case, the petitions under Section 28A of the Act has been filed in the year 1995 while the corporation came into existence on 1st October 1998, while the award has been made before the collector and subsequent to its coming into existence, that is 20th September 2003. Thus, we are unable to accept the contention of the respondents that the corporation is neither a necessary nor a proper party and cannot participate in the proceedings merely because it came into existence subsequently, as it has it has taken over all the rights and liabilities of the erstwhile department. It would be exclusive responsibility of the corporation to pay enhanced compensation. It has every right to participate in the proceedings. So, my lord, so, my lord, this is one, my lord, which will have I'm only reciting it for persuasive effect. So, my lord, this reasoning, my lord, carries a lot of weight, because ultimately, what is important here is, my lord, if the assignment is for a public purpose, that stands again on a different footing. If it is for a different purpose, commercial, my lord, that's a different thing. Then your lordship will make that distinction. Because ultimately, what you are doing is by challenging the authority of the state to get public projects executed in a particular manner. Now that the government, my lord, the state has the power and authority to do it because it is within the remit of its legislative powers. It's an entry 17 of list 2. Irrigation comes under. So the state has the power to assign it, get it executed in any manner. One of the arguments can be made is that, look, this project is not a public project. It has nothing to do with public purpose. It is for a commercial purpose. So then, my lord, your lordship will take a different view. Then all the arguments about assignment, etc., will not come in. But it's a completely private purpose. The state cannot misuse its authority and do something, my lord, for the benefiting a public, a private party. So therefore, my lord, here also the court, my lord, as in the Supreme Court judgment, both were government, my lord, there was projects relating to irrigation or water, drinking water. So the government has the authority to do those work discharge in a particular manner. The underlying test under the scheme of the act is who bears the compensation. I am a distinct legal entity from the state. The state has more than 51% shareholding in me, but I am a distinct legal entity. I am a government company. I am not a private company as normally understood. I have certain objectives to be discharged, all in larger public interest. I can sell my land. I can mortgage my land. Lord, I have all those, the compilation of documents that I have filed, your lordship will find my entire lands are, and virtually the entire lands are mortgaged with various banks. Because why? The government says, we don't have the funds, or we will use that funds in a more beneficial manner, maybe to make it more efficient use of public funds. But for these projects, you have other ways of raising funds. And that's why we create government companies. So to say that I am not an alter ego of the state, I have certain financial responsibilities. I am supposed to manage my affairs in an independent manner. I am not required to go back to the government. But yes, eventually if we succeed as this special purpose vehicle model, I would not have to even borrow monies from the government by way of grants. That's the whole objective, Lord. That's a maturing process. I don't know how long it will take because it's a different mindset. But today, your lordship saw the 9 judges bench judgment. So the point is that the court says you can't use 31C for the purpose of acquiring every citizen's land. But acquisition of land, requisition of property of a private citizen can be undertaken for the purpose of meeting certain obligations in larger public interest. So that is a different concept. So this is an evolution in terms of governance, and your lordship knows, your lordship sees it every day. The state is in a retreat mode. It is retreating from its traditional spheres. It has to find means for funding public projects. Lord, I am aware of one, Lord, in Kerala, for example, they have a government entity whose only mandate is to, Lord, improve the standards of schools, government schools, making it, Lord, making electronically accessible, Lord, internet, equipment, etc. So there's a government company whose only job is to upgrade government schools. And how does it do it? By creating a government company, you borrow funds from the market. It's not a revenue generating activity. So these are innovations. Now, my lord, this kind of reasoning, my lord, as your lordship sees here, the retreating state by assignment or whatever means, the government tries to do it so that the public funds can be used more efficiently. The mere fact, my lord, as your lordship were pointing out to me, your documents indicate that you are getting money from the fund. That is done by way of grants. It gets converted into equity. The government's stake in the company keeps increasing. So because the government is the owner of the company, but it expects me to raise funds from the market and diligently, my lord, utilize those funds. So how do I do that? I have to object and contest matters where compensation is not justifiable. I apply my own mind. I don't take recourse to the government to seek their opinion as to whether I should challenge a particular order and giving enhanced compensation. I do it entirely on my own. That's my mandate under my articles and memorandum of association.
But there can also be another argument against you,
Yes.
that though this project was entrusted to you in the year 2005, and you knew several appeals were pending, why didn't you file an application?
My lord, we didn't know. That's the whole problem.
You can't say we didn't know,
My lord, that's
because the project itself is
no,
entrusted
my
to
lord,
you.
as far as those 2000 odd,
Project has been entrusted to you.
yes.
And you are aware that several appeals have been filed seeking enhancement, reference,
Yes.
then enhancement, then appeals.
No, my lord, we have said in all these matters, we have said we were not aware. We were not parties.
That is
Lord,
why they are arguing
my lord, in fact, my
that
lord,
you cannot say so, because your own special land acquisition officer sitting in your office is aware of all these things. And if he doesn't bring it to the, to your notice, then who is to be blamed?
my lord, not me. That's my point. Not me. My lord, in fact, sorry.
That's correct.
My lord, number one, my lord, I must clarify this. The special land acquisition officer is not my officer. He is the officer, he represents the state, the eminent domain. The mere fact that he sits in my office is absolutely of no relevance. That is why, my lord, your lordship saw in the Kerala Water Authority judgment, one of the arguments made was your persons appeared as a witness in the proceedings. So you have constructive notice of these proceedings. The Supreme Court rejected that argument. And in the other case, the Agra development case, which was cited, the minutes of the meeting was, enhancement of compensation was attended to by the beneficiary's officer. The Supreme Court rejected that argument also. My lord, I must make it clear that the special land acquisition officer may be physically sitting in my office, but he is not answerable to me. He is not, he does not exercise any supervisory power over the Nigam. His job is only to.
Question was, why didn't you file an application to implead yourself to protect your interest?
My lord, I take it against myself that I did not do it. I instead filed a writ petition. In a particular context, in a factual background, my lord, I had to file writ petitions because that is when the execution, my lord, I got aware of the execution. That is why these writ petitions were filed. Now, my lord, that your lordship will take into account that did I sit over it? Did I fail to discharge my duties? My lord, there must be some pleading, some evidence to that effect that yes, you were aware of it. You were dealing with those matters. You did not, yet you did not do anything. Maybe, my lord, I am not saying my clients were absolute. Maybe in some case it would have happened. I can't say that we were, my lord, there could be some kind of notice, but we never had legal notice of these proceedings. That's the reason. That is what we have shown in the writ petitions. We were not aware. And even today, my lord, we still do not know. That is obviously because of some administrative or structural, my lord, issues that there is no reporting system. We are setting it right, my lord. We are dealing with all those matters because even as we speak today, we are only aware of those many writ petitions that we have filed. There may be hundreds and thousands of other matters that we are not aware of. My lord, I am saying that so very candidly, my clients also tell me we are not aware because there is no systemic architecture within the organization or an interface with the government where we can get those inputs. So now, my lord, because of the magnitude of the issue is so large, and my lord, the state ultimately, yes, ultimately, whatever form, whether it is by way of borrowings from the market or by grants given by the government, it is public money only. So without a contest, and what is happening in all these matters is because, my lord, I must tell you this also. In all these matters, what is happening is enhancement is being sought for in an appeal filed after 5,000, 10,000 days delay on the basis that in relation to the very same project in another village, compensation was given. And my lord, in a large number of matters, my lord, which we went to Supreme Court, we filed permission to file SLP. The Supreme Court, my lord, allowed our appeals. There is by detailed judgment that is also on record. And they have sent it back to the court, the High Court, asking them to determine these cases by applying the relevant law. Now, you don't lead any evidence in the appeal. You come after 7,000 days, 20,000 days. Lord, those orders, Lord, I placed on record in this very compilation at page 81. These are remanded matters and matters where we were not, most of these matters, we were not parties. We had to file permission to file SLP and matters have been remanded back. Lord, the first of those orders are at page 81. And Lord, the order starts at page 86. Same, Lord, we were not made parties, announcements granted, Second appeal, at the second appellate stage, we get to know because they come with execution warrant. That is when we file SLPs. Now, Lord, please have a look at this, Lord. Just have a look at the kind of, in Lord, the High Court, Lord, I will not, Lord, your lordships are not Lord, aware of those positions. Now, because there is no contest by the other side, government lawyers are not properly instructed. They are not aware of the situation. So what is happening is, Lord, just have a look at para 3 at page 86. What is happening? The High, Lord, just please see this. Yes. The High Court essentially followed the earlier decision in respect of land situated in Harkanchi. Now, please note, my lord, these are not matters relating to Harkanchi, which in turn followed the decision in respect of the land situated in Mattimadu village. These villages are not in contiguity. My lord, they are like 20 kilometers apart. The reference court in the first decision concerning Mattimadu has arrived at a compensation amount of 2,08,000 per acre in respect of notifications dated 18th March 1999 issued under section 4. That decision was followed in a subsequent case decided in respect of Harkanchi village being lessee number so-and-so decided on 7/1/2016, albeit in respect of a notification of 11/4/1985. Please see 99 and 85 issued under section 4. In that case, the reference court has awarded compensation of 1,20,000. As aforesaid, the High Court in the imputed judgment has essentially followed determination by the concerned reference court in two different sets of acquisition proceedings under the different notifications, including different villages unrelated to the villages covered under the present appeals concerning the Benetora project. And Lord, then they refer to Manoj Kumar, and Lord, that's a basis. Now, what is happening is all these cases is mechanically, Lord, because the government councils are not Lord, properly instructed. They are not aware of the position. These kind of orders are passed. And why, my lord, the problem with our problem is, my lord, these are all linear projects. So if it's a 200-kilometer long project, there are maybe 50 or maybe 200 villages across the board. So one leads to, it has a cascading effect. So regardless of the nature of the land.
Probably we are also guilty of passing such orders.
but there has to be assistance.
Reading this, I feel we have also passed such orders.
Yes.
At the instance of the claimants.
One of the judgment he handed over today to your lordship. So that's the problem, Lord. And linear projects, one village, the other way, every village is contiguous to each other. So 200-kilometer long project, we have to pay uniform compensation without being given an opportunity to show. If you have intrinsic evidence to show that, yes, my land also, I was also growing sugarcane. This is a yield certificate I have, which is at par with that particular village, then yes, there is material. But without any evidence being discussed, merely relying on some other. And ultimately, all these cases related to Mattimadu village, which is a village which is not even contiguous to these villages. And just see at para 90, page 90, my lord, sorry. Right on top. In the impugned judgment, the High Court has not made no effort to analyze concerned case, either notification-wise or for that matter, village-wise, including other parameters required to be observed for arriving at a just compensation. Yes, evidence, my lord, a judgment is a piece of evidence provided there is substratum to show that their judgment is applicable. None of these cases, my lord, the High Court has been persuaded to look at to that intrinsic evidence. That's a problem. And Lord, also next paragraph, my learned friend rightly points out, further in most of these appeals, the appellant Nigam is not made a party in the appeal proceeding before the High Court. So that's the problem. So, my lord, we are coming to life about our responsibilities at this late stage. I must confess that. But my lord, we want to make it good. My lord, ultimately, there is the public also expects us to take care of these interests. Yes. My lord, the next remand order is at page 107. My lord, again, following the same. The Supreme Court. Yes. Page 107. I will not trouble your lordship reading it. They have reiterated the same position. It's a different bench, but just, my lord, yes, my lord, at para 10, if page 110, just have a look at para 5 only. That's all. Which is, my lord, this batch of matters includes the very same project that we are dealing with, Amarja project. Lord, para 5, the corporation has been entrusted with the assignment to plan, execute and operate drinking water and irrigation projects and schemes in the state of Karnataka. About 13,000 acres of land was acquired in the state of Karnataka for the appellant corporation for various projects like Benetora, Gandori Nala, Lower Mullamari and Amarja project. We are, my lord, this case pertains to Amarja. Certain civil appeals also and so, my lord. So, this, again, they followed this previous order. and these have been remanded back. That's all right. And my lord, what is also happening is, today the position is many of these matters, the remanded matters, my learned friend appears in those matters. My lord, we are in the midst of hearing that those matters also. My learned friend makes concession that yes, I'm giving up my objection that Nigam is not required to be a party. He makes concessions to get matters decided. Now that kind of, you can't, my lord, these kind of matters can't be decided on concessions. It has to be decided on some principle of law. That's why, my lord, we want your lordship. My lord, that order of concession is also on record at page 119 in the very remanded matter which I showed your lordship. That, my lord, at page 119, order of 24th of June 24. He makes a concession. Well, I give up my objection that KNNL is not required to be made a party. And my lord, the objection is made even after the Supreme Court allows my permission to file SLP. These are civil appeals. Doctrine of merger applies. He still expects me to make out a case that I am a party in the remanded matters.
Where is that concession?
My lord, page 119, para 5 at 120. My lord, para 6. My learned friend submission starts at para 5. However, notwithstanding the aforesaid objections raised by him, he would fairly submit that for the purpose of appeals now listed for consideration, in view of the fact that these appeals are remanded by the Apex Court for fresh consideration on the lines of the observation made in the remand orders that were passed at the instance of the Nigam, to that limited extent, he submits that the landowners have no objection to bring the Nigam on record as party respondent. However, he submits that his concession given by landowners in these appeal shall not come in their way of their other collateral proceedings which are otherwise which are pending consideration. You can't have this kind of this is not a matter of strategy. It has to be decided on legal principles. So that's a problem that we have. Now, my lord, yes, my lord, I wanted to show your lordship that 2014 judgment where a learned single judge said that the government will not contest these matters, only the Nigam will do it. Lord, that is page 198. Page 76. No, I'll just read this is a short order.
198 is what?
198 is the judgment of the learned single judge saying that the Nigam will only contest the appeals, not the government. Page 198 and 199.
Yes.
This appeal is by the state government assailing the judgment and award made by the reference court in enhancing market value determined by the special land acquisition for Niravari Nigam. It is not the case of the appellant that even though the quantum of compensation awarded by the reference court is on a higher side, the beneficiary in whose favor the land was acquired by colluding with the claimant has not been taking steps to challenge the award made by the reference court enhancing compensation awarded by the land acquisition officer, and therefore the state is preferring this appeal. On the other hand, it is submitted by the learned High Court government pleader appearing for the state that the Niravari Nigam has filed an appeal MFA so-and-so challenging the judgment and award impugned in this appeal. If that is so, this appeal filed by the state government, which is not agreed by the award, is misconceived and is liable to be dismissed as not maintainable. Under the above circumstances, it has become necessary for this court to observe that in cases where the state government acquires lands of private owners for the benefit of third party, generally it is not agreed by the acquisition of such lands in spite of that.
Yes.
Para 4. Under the above circumstances, it has become necessary for this court to observe that in cases where the state government acquires lands of private owners for the benefit of third party, generally it is not agreed by the acquisition of lands. In spite of that, the government has indulged in filing appeals in such and similar cases by spending public money unnecessarily, and it has become a big litigant before the court of law. In one such case, the state government, after filing appeal challenging the award made by reference court has issued a government order stating that no appeal need be filed. Therefore, it is necessitated this court to direct the registry of this court to send a copy of this judgment to the Law Secretary, Department of Law, so that henceforth the state government should avoid filing appeals in such similar cases. For the reasons stated above, when the court was about to dismiss the appeal, learned government pleaded submit that the appeal may be dismissed as withdrawn. Now, pursuant to this order, my lord, a GO was issued, which is at page 76. My lord, the judgment which I read was dated 7th of January 2014, and the GO has been issued on 1st of July 2014. And it says, a copy of the judgment of 7th January passed by the Honorable High Court so-and-so is enclosed herewith, which is self-explanatory for kind information. It has brought to the kind notice as observed above in the judgment, when the land is acquired for the benefit of third party, the state need not file appeal against the judgment award passed by the reference court, since it is only an acquiring body. It is for the beneficiary to challenge the judgment and award passed by the reference court if aggrieved by the award. Therefore, in view of the said judgment, it is hereby directed that henceforth the state government would avoid filing appeals in such similar cases. Such direction may kindly be treated as a note or taking decisions on file applications on behalf of the state. And your lordship may say that it is marked to the irrigation department, etc. So, my lord, what it means is, if the government cannot file appeals and nobody will file appeals, we are also not required to be, my lord. So there can't be a void in these kind of matters when you have a live project, a live issue. So, and my lord, this has been followed. Of course, in many of these cases, the government lawyers, I don't know for what reason, my lord, the learned AG will be, my lord, making submissions on that. There is a systemic problem here. And in spite of this GO, my lord, the learned AG has found out that there are so many other cases where the government lawyers have been appearing in the matters, in spite of these government instructions. The learned AG will make submissions on that. I don't want to talk about it. But so there, my lord, there we are, my lord, this court has itself passed this order. There's an mandamus issued. Yes, and Lord, there have been, this year also we have issued, the government has issued notifications, which your lordship will find at page 77 to 80. There have been two subsequent in 2024 also. Now the government, my lord, is also taking serious note of all these. They are also, my lord, acting proactively. They are also, yes. Yes. Now, my lord, this, my lord, your lordship notices that these instructions are circular to all the nigams, not only me, everybody. Now, my lord, I'll just, my lord, take your lordship to the two judgments that my learned friend relies upon, that is that Pirappa and that Sharma. My lord, that your lordship will find at page 201. Pirappa is 201. A fairly lengthy order, but I want your lordship to just have a look at the core reasoning of the court as to what is a. I think
Of course, it arises out of KID Act.
KID Act. Now, your lord.
The challenge was sought to be raised by an allottee.
Allottee. And there, my lord, how does the court say that the allottee has no locus, my lord? Because, my lord, just come to, my lord, para 49, para 49, my lord, at page, yes, para 49, page 222. Mm-hmm. 49 to 54 is a relevant portion, but I'll just read this portion. May I read, my lord? Yes. Para, my lord, 49 onwards I'll read. Lord, in fact, your lordship may come to para 47, just to give that, to maintain that continuity. Para 47. In the appeals, that's page 221. In the appeals arising out of SLP so-and-so, it has been specifically mentioned in annexure P1 that the lands specified in the schedule mentioned in the notification are required for development by KIADB for establishment of industries therein. In exercise of powers conferred under subsection 1 of section 28 of the KIADB Act, the state government has given notice to the landowners of its intention to acquire the said land in favor of industrial development by KIADB. Clause 1 of annexure P5, which is a copy of the agreement made between KIADB and Rashri Cements, reads thus. The relevant portion, Lord, the italicized portion your lordship may see. In consideration for a sum of rupees so-and-so paid by the lessee to the lessor as premium and rent hereby reserved and of the covenants and agreements on the part of the lessee hereinafter contained, the lessor hereby demise into the lessee all the piece of the land known as survey number so-and-so and more fully described in the first schedule hereunder written and delineated on the plan annexed hereto and thereon surrounded by a red color boundary so-and-so, 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 and then Lord goes on. And then Lord, please come to para 49. The said lease is executed between the parties, that is KI.
Learned Senior Counsel. My brother is another bench constituted between Bangalore and Kalaburagi. So we will continue. When do you want?
We also conclude on that 12th, Malad.
Yes.
12th.
Want it on 12?
12th, Lord.
We'll have it at 2:30.
2:30.
Huh?
Yes.
I think it'll be sufficient.
Yes. No, I'll conclude now.
Release this matter on 12th of November at 2:30 p.m.
2:30.
For further argument. Yes. Appeal. Huh? Number 46. Appeal. Take some date. Please take tomorrow.
My lord, serial number 26 passed over matter. Serial number 26 passed over matter. Date may be fixed.
Pass over ಮಾಡಿದ್ದು ಏನ್ ಮ್ಯಾಟರ್ಸ್ ಅದು
Service matter, 80.
Huh?
Tribunal, from tribunal. Promotion.
ಅದರದ್ದು ಒಂದು ಡೇಟ್ serial number. Huh? Sir.
Serial number 43, Lord. Serial number 43. It is for suspension. May I seek it for tomorrow, Lord? Since I'm
Tomorrow it's not possible, sir. We'll have it day after.
Since I'm coming from Dharwad, Lord, I'll take chance, Lord.
Huh?
I'm coming from Dharwad.
Huh?
I'll take chance tomorrow. Hardly I'll take 3 to 4 minutes, Lord. That is.
Password date.
ನಾಳೆ
ಡೇಟ್ ಕೊಡ್ತೀನಿ ಯಾವತ್ತು ಓದ್ಬೇಕು ಬನ್ನಿ
43.
43
ನಾಳೆ
ಇಲ್ಲ ನಾಳೆ ನಿಮ್ಗೆ ಒಂದೇ ಹೇಳಿದೆ ನಾಡ್ದಂತ 46 ಅಲ್ಲ 26/11 ಓಕೆ ಆಯ್ತು ಸರ್ 17 ಅದು ಸೀರೀಸ್
ಅದು 12ಕ್ಕೆ ಅಲ್ಲ 12ಕ್ಕೆ 12 ಅವ್ರು ಇವು ಬರ್ತಿದಾವೆ.
ನೀವು ತಿಳ್ಕೊರಿ ಸಾಮಾನ್ಯ ಹೇಳಿ ಕೊಡ್ತೀನಿ.
ಇಲ್ಲ ಬೇಡ ನಾಡ್ದು ಬೇಡ 12ಕ್ಕೆ ಇವತ್ತು ರೆಡಿ ಇದೀವಿ ನಾವು ಅದಕ್ಕೆ
11th ಕೊಡ್ಲಿ 11th ಕೊಟ್ಬಿಡ್ರಿ. 11th ಇಲ್ಲ ಮೇಲೆ ಬರ್ತದೆ 12th ಕೊಟ್ಟರು ಕೂಡ ಮೇಲೆ ನೀವೇ ಇರ್ತೀರಿ.
11th
11th ಒಂದ್ ನಿಮಿಷ ಅವ್ರದ್ದು ಮುಗಿಲಿ. 17, 18 up to 20.
Agriculture department ಇದು.
ಇವರೇ ಅಲ್ಲ ಮಾಡ್ತಾರೆ
Right, okay. ಕೊಟ್ಬಿಡ್ರಿ ಫೈಲ್ ಕೊಟ್ಬಿಡ್ರಿ 9.
ಹೇಳ್ರಿ ಇವತ್ತು ಅದು ಕೊಡೋದು ಹೇಳಿ.
ನಾಳೆ ಮಾಡು, ನಾಳೆ ಕೊಡಲ್ಲ. 11th ಕೊಡೋಣ, 11th. 59 ಸರ್ ಅದು. ಓಕೆ. ಹಾ, ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂಬೇಕರ್ 11th.
ಸರ್ 37 ಅದೇ ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಸಾಹೇಬ್ರು ಇದು ಅಂದ್ರಲ್ಲ ಅದು
ಅದು
11
ಕೇಳಿ.
ಇಟ್ಬಿಡಿ, ಕೇಳ್ಬಿಟ್ಟು 11 ಇಟ್ಬಿಡಿ.
54, 22nd.
ಕೊಟ್ಬಿಡ್ರಿ, ಇಲ್ಲೊಂದು ನಮ್ಗೆ ಬಂದಿಲ್ಲ ಅದು ಬಂದು
22nd ಬೇಡ, ಫ್ರೈಡೆ ಕೊಡಲ್ಲ, ಬೇರೆ ದಿನಕ್ಕೆ. 25th 54, ರೈಟ್.
41 ಯಾವಾಗ ಇಡ್ತೀರಿ ಸರ್?
50 ಯಾವಾಗ ಬೇಕು ಸರ್?
41 ನಾಳೆಗೆ ಇಟ್ಟರಲ್ಲ.
ಅದಿದೆ ಡಿಟೆನ್ಷನ್.
Do it.
ಓಕೆ. 48. 48 ಯಾವಾಗ ಬೇಕು ಸರ್ ಇದು? 14th, ಓಕೆ ರೈಟ್, ಆಯ್ತು. 13. ರೈಟ್.
Serial number 40.
48 ಅದೊಂದೇ ತಾನೆ. 48 and ಕನೆಕ್ಟೆಡ್ ಮಾಡಿ. ಆಯ್ತು, ಒಂದೇ ಲೀಡಿಂಗ್ ಕೇಸ್ ತಗೊಂಡು.
41 ರೀ.
41 ಇವತ್ತು ಬೇಕು.
Monday.
11th.
Serial number 40. Day after tomorrow.
7th, ಓಕೆ. ನಿಮ್ದು ನಾಳೆ ಸ್ವಲ್ಪ ಇದು ಕಳಿಸ್ಬಿಡೋದು, ಗುಂಪು ಕಳಿಸ್ಬಿಡೋದು. 43. ಕಳಿಸ್ಬಿಡೋದು. ನೋಡ್ಕೊಳ್ಳೋಣ ನಾನು. ಇದು ಇದ್ರದ್ದು. ಹಾ. ಇವ್ರಿಗೆ MSR ಕಳಿಸ್ಬೇಕು ನೋಡುದು. ಇದೊಂದು ಕಳ್ಸಾಕ ಅದೊಂದು ಡೇಟ್ ಕಳಿಸ್ಬಿಡ ಹಂಗೆ. ಸರಿ ಎಲ್ಲಿಗೋದ್ರು ಅವ್ರು ಕಳ್ರ?